Items for pronouncement of judgment. Item 1, MSc Appeal 22 of 2021.
Appeal dismiss.
Item 2, WPC 1005 of 2025.
Petition dismiss.
Item 40, WPC 7474 of 2023.
Partly allowed.
Wait, please, Your Lordship. Should I pray for listing of an IA, my lord? The RSA has already been listed on Monday, my lord. Connected IA has not been listed, my lord.
Monday.
Already listed, item 15. Okay, deeply.
May I please, Lord? I would like to mention item number 22, Lord.
Yes.
I'm representing for, actually, there are two cases should be tagged on. One is at defect counter still now. So we need 4 weeks time, Lordship.
Mr.
PD Bhuya.
Learned counsel for the appellant.
PD, yeah, clear.
Press for listing the matter after
4 weeks.
4 weeks.
Month.
This is along with the RSA number 76 of 25.
77.
No. Okay.
What's up?
May I please, Your Lordship? May I please, Your Lordship? Lordship, I beg to mention item number 10 and 11.
10 and
10 and 11.
10 and 12.
11.
10 and 11.
Yes, Your Lordship. Lordship, the engaged counsel for the petitioner, Mrs. A. Bujarbura, due to some medical emergency, she couldn't come today. So the matter may be adjourned for the day.
Okay. Your good name, please, Miss
A. Sharma.
A. Sharma, learned counsel appearing on behalf of Mrs. A. Bujarbura.
Yes, Your Lordship.
Learned conducting counsel for the petitioner. Rest shall principal listing the matter
After next week, Your Lordship, on
next week.
yes, Your Lordship, on next Friday.
Next Friday.
Part
Next Friday, this court will not be available.
Any date, Lord,
Any date?
on Lordship availability.
On is 16th June.
16th. Much obliged.
There, look.
May it please, Your Lordship, I beg to mention one RSA. The matter may be listed on the hearing column, Lordship.
When?
And that may be given in the
On 5th
next
June.
week, 5th June. Lordship,
May I please, Your Lordship? I beg to mention item number 47 of the supplementary list, Your Lordship. With the consent of the other side, the matter may be possible for the day.
47.
Yes, Your Lordship.
Miss, your good name,
Supplement-
please.
R.A. Chaudhary.
R.
R.A. Chaudhary.
R.S. Chaudhary.
Yes, Your Lordship.
Learned counsel for the respondent with consent from the other side, press for listing the matter. When?
Any day, Your Lordship.
After a week?
Your Lordship.
Okay. After a week. There, look.
Lordship, there is another matter, but it is to be listed in the hearing column, Lordship.
When?
Next week, any date may be given.
Take it that purpose.
On 2nd June.
Please, Your Lordship. I
Second-
beg to mention for listing of an in-test case, Lordship, for hearing on 27th
27 of this
May.
month.
Yes, Lordship.
27.
This is an urgency,
On
Lordship.
29th.
29th. Lordship.
May it please, Your Lordship. Lordship, I beg to mention for listing of two connected CRP, Lordship. It's an eviction matter, Lordship. One CRP is filed by the landlord and another by the tenant, Lordship.
When do you want?
Lordship, a short date may be given because, Lordship, it was last listed in the year 2024, Lordship.
28.
28. Obliged, Lordship.
Yes.
Please, Your Lordship, Lordship, I beg to mention for listing of one RSA in hearing column.
When?
Maybe on next week, any date.
On
Next
hearing
week,
column. 5th June.
May it please, Your Lordship. Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 14. Lordship,
1-4.
yes, Lordship. Can it be taken, Lordship, on 12th of June, Lordship?
June.
12th of June, Lordship. It is the date given by
Mr. D. Upamanya, learned standing counsel for the higher education department with consent from the other side, press for listing the matter on
12th of June.
12 of June. There, look.
Highly observed.
May I please, Madam? I pray for listing of an MSc appeal for orders, my lord, in the first week of June, my lord, any date, my lord.
When?
In the first week of June, any date, my lord. MSc appeal
Okay.
for orders, my lord.
5th June.
Obliged.
It is your lordship.
Yes,
Lordship, yesterday one case was fixed, lordship, earlier, which was part heard by your lordship.
Mm.
Writ petition. So yesterday your lordship did not sit, so it did not come. It's a very, urgent matter, lordship. Can it be fixed in the next date, in the next week, any date convenient to the court?
next week, for coming 2 week, this court will not be sitting here.
Oh.
So after 2 weeks, you can
Okay.
choose any date from him. Or I can release the matter from.
No,
being
lordship,
started.
substantial hearing was done, lordship.
Okay, okay.
Okay, on 10th June, 10th June. 10th June.
Need your best.
Item to be spoken to.
Yes.
Items 41 and
Received your instruction.
Lordship, I have prepared my written argument and some citations also I will place before the Lordship. Lordship, I take up kindly at 2 o'clock, Lordship.
When?
2 o'clock today.
Today?
Today too. I will place
Okay,
the
okay.
written argument and citations, Lordship.
But furnish a copy to him also.
Lordship, I will
He
furnish.
may also require to
Lordship.
reply.
Lordship.
Yes.
Obliged.
For motion item 3.
My lord, 83-year-old person purchased land in 64 and decree obtained, my lord, by the trial court, upheld by the appellate court and second appellate court. And now the executing court, my lord, has rejected his petition, my lord. It's clear, my lord, saying that the land is not identifiable. My lord, can it be possible, my lord?
Okay, let notice go at this.
At least the notice will go, my lord. That is why I am not pressing everything, my lord.
Heard Mr. G.N. Sayola, learned senior counsel assisted by Miss
Estodi.
Tode, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 19/8/2024 passed by the learned civil judge senior division Gulagat in Mijje case number 18 of 2015, wherein the petition filed by the petitioner under Section 47 CPC for issuance of fresh warrant of possession to the bailiff within the Nazir of the court to execute the decree was rejected and dismissed. Peruse the petition and the documents placed on record. Then also peruse the impugned order dated 19/8/2024. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Item number 4.
May it please your lordship. Lordship, in this case, this petitioner is in default in filing the written statement within 90 days, lordship. The order I have challenged that is on page 22, lordship. In a similarly situated case, lordship has granted in one circumstances, lordship considering the lordship with the post after allowed to file written statement, lordship, with a cost. Lord.
So why you could not file the written statement?
Lordship,
within time?
actually, she didn't consult with the advocate and last moment, lordship, when she prepared this, lordship, the court say it's already over. That's why, lordship. Already, lordship, I have annexed the lordship written statement that is on page 23, lordship. Otherwise, it is ready, lordship.
Delay of how many days?
Lordship, now, lordship, the lordship limitation over on 22/1/2025, lordship. Now almost 3 months.
On?
Lordship, he's received the summon on 22/10/2024, lordship. Now it is over on 22/1/2025, lordship.
Received the summon on
Received the summon on lordship 22/10/24 lordship. That is reflected in the order lordship.
and he was supposed to file written
Within
statement on
22/1/25 lordship.
20.
22/1/25 lordship. Now
And when you have filed a written statement there,
here we filed this petition on 6/5 lordship. This writ petition filed on 6/5.
no, there.
There we could not file lordship.
Have you enclosed the written statement?
Yes, lordship, that is
But-
on page 23 lordship.
But while filing the application before the trial court, whether you have enclosed the written statement,
No lordship, that was not enclosed.
and when you have filed the petition,
This petition lordship, this writ petition lordship. This writ-
no. That petition before the trial court,
And that reflect lordship
27.
27/2/22 lordship. Now lordship, next day is for necessary order 27/6/25 lordship. Otherwise lordship is
Or
matrimonial.
is the disorderly learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the correctness or otherwise of the order dated 27/2/2025, passed by the learned Principal Judge Family Court, Nalbari. It is to be noted here that by order dated so the learned Principal Judge Family Court, Nalbari has dismissed the petition number 87 of 2024 filed by the petitioner for allowing some time to file a written statement, as the written statement could not be submitted on that day. Mr. Sotori, learned counsel for the petitioner, submits that the petitioner is the petitioner or respondent there.
Petition here in this respondent in
trial
that
court.
case lordship. Divorce case lordship filed by the husband. Here the petitioner is a wife lordship.
That the petitioner is the respondent in the matrimonial suit number, matrimonial suit within bracket capital D 199 of 2024. And the said matrimonial suit was instituted by her husband. The petitioner has received summon from the learned, no, from the court of learned Principal Judge Family Court, Nalbari on 22/10/2024. And as such, she ought to have filed a written statement on 22/1/2025, but she could not consult her counsel in time, and therefore she could not file a written statement before the learned trial court. And as such, Mr. Sodhuri submits that the petitioner herein may be given one chance to contest the said matrimonial proceeding before the learned Principal Judge of Family Court, Nalbari, by granting an opportunity to file the written statement. By filing written statement. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 27/2/2025. It is well settled that the rule of filing WS within the 90 days is not an inflexible rule. On sufficient ground being shown, the court may, extend the same beyond 90 days. The case in hand, the learned counsel for the petitioner submits that the petitioner could not consult her lawyer within the stipulated period, or no, within time for which he could not file the written statement within the stipulated period of 90 days. And taking note of the submission of Mr. Soturi, and also considering the facts and circumstances on the record, this court is inclined to allow this petition. The impugned order dated 27/2/2025 is considered set in force. Consequently, the learned Principal Judge Family Court Nalbari is directed to accept the written statement filed by the petitioner and to proceed with the suit in accordance with law. However, the petitioner has to deposit the sum of rupees 2,000 being the cost before the District Legal Service Committee Nalbari
Highly obliged.
before the date fixed.
Highly obliged.
Items for admission, item number 5, order matter.
My lord, it's regarding permission to appear in the LLB 10th and 7th semester examination, way back in 2017. My lord, my learned friend is relying upon.
No, Mr. Fukon, on the other day, we have already heard the matter.
My lord,
We cannot reopen the matter again.
no, my lord,
Today is fixed only for submission of one citation by you.
my lord,
Submit the
my
citation.
lord, I will file the citations, my lord, but only that last page 33.
Pardon?
In the context of page 33, I am filing the citation, my lord. I am submitting the citation, page 33. The last two paras, page 33. I'll be very brief, my lord. Faced with such a situation, court is of the view that two situations visualized under Regulation 14C may have to be reconciled, and a view that emerges out of such reconciliation appears to be in favor of the candidate. Moreover, having regard to the facts and circumstances of the case, it may not be wrong to accept a view which is more favorable to the candidate. On due consideration, court is of the view that it would meet the ends of justice if the petitioner is allowed to appear in two papers, namely so-and-so of 7th semester of 5 years BLLB honors course as and when the examination is held next. Read petition is allowed, but without any order as to cost. My lord, here the rule 14C has been mentioned, but the earlier page, the notification, the rule 14C is about the 9 years course, not 8 years. But the earlier page, notification, last but two para, notification of the Guwahati University dated 18/4/2012. It stipulates 8 years. And the regulation 14C stipulates 9 years. But without deciding that aspect, my lord. So the entire judgment has been passed sub silentio, my lord. I'll place the citation, my lord, regarding that sub silentio aspect. Whether that notification of 2012 regarding 8 years course and whether that 14C regulation regarding 9 years course, which is acceptable in the eyes of law, that aspect has not been discussed, my lord. It is
No,
only
whether
on the
at
equity
that point
consider-
of time, it was pointed out to the court.
My lord,
Whether standing council of the Guwahati University has pointed it out to the court.
my lord, it is not clear from this judgment.
Then
But that sub silentio, my lord, judgments, my lord. I want to place the citation, my lord. Eto niba niki? Only one para, my lord. Para 11. The Municipal Corporation of Delhi versus Gurnampur, 1989, 1 SCC 101. Para 11. Down below. Para 11, my lord, down below last 5 lines, referring the Salmon jurisprudence 12 edition. The concept of sub silentio at so and so in these words. A decision passes sub silentio in the technical sense that has come to be attached to that phrase when the particular point, next phrase, of law involved in the decision is not pursued by the court or present to its mind. The court may consciously decide in favor of one party because of point A, which is considers and pronounces upon. It may be shown, however, that logically the court should not have decided in favor of the particular party unless it also decided point B in his favor. But point B was not argued or considered by the court. In such circumstances, although point B was logically involved in the facts and although the case had a specific outcome, it is important. The decision is not an authority on point B. Point B is said to pass sub silence. So whether that 8 years course or 9 years course regulation.
No, Mr. Pukon,
Miller,
in fact, in this order,
Miller,
no law has been laid down by the court.
Miller, that is one aspect, Miller.
Ah,
Since Miller, the candidate,
ground for referring this order by the counsel for the petitioner is that similarly situated circumstances, one of the petitioner was allowed to appear by the court.
Miller, factual differences are there.
Maybe
Most
there might be
vital
some
aspect,
factual difference.
she was married in the meantime. Tulika Bharli, that case, Miller, case 33.
No, we are not
Married and,
concerned with whether the
that was on
petitioner
the
is married or unmarried.
Equity consideration, Miller, this judgment has been passed. There is another crucial aspect, Miller. But here, as regards the writ petitioner, no reason has been cited why she has not appeared. Miller, another judgment, Miller. Only that judgment I will place, Miller. Para 48. Urbansal Cables and Conductors Private Limited, 2012 5 GLT, Supreme Court 1. Miller, the page 48, next page, Miller. Para 48 in the middle portion, Miller. In other words, can such conclusion be considered as declaration of law in the middle portion? Here again, the English courts and jurists have carved out an exception to the rule of precedence. It has been explained as rule of sub silentio. It is important. A decision passes sub silentio in the technical sense that has come to be attached to that phrase when the particular point of law involved in the decision is not pursued by the court or present to its mind. Salmon on jurisprudence 12 edition, Miller, the same law Miller has been already explained in the earlier judgment. Now, Miller, most crucial aspect of the matter is that this decision has been passed in 2016. Tulika Bharli was registered in 2008. The writ petitioner also similarly situated in 2008. But when the entire examination is over, she has filed this writ petition. Kindly note the date. Date of the earlier judgment. Page 32. Judgment date 27/10/2016. Registration date, third para. JB Law College, Guwahati University on 23/6/2008. Exactly similarly situated. But the decision was of 2016. Now, this petition has been filed. Most interesting, Miller aspect, Miller, on 28 June 2017. The exam was held in June 2017. Kindly turn to page 28. The exam sheet. It is from his petition, page 28. Page 28, it's regarding 8th semester, and page 29, it's regarding 10th semester. The exam starts from 29 June regarding 10th semester, and regarding 8th semester, 30th June. And it will end, it was to end in 18 July. The date is important, Miller, 18 July 2017. And regarding 10th semester, the exam was supposed to end on 17 July 2017. Now here, the writ petition was filed on 28th June 2017, but registration was done on 31 July 2017, when the entire exam is over. It is from the official website, Lord, I have collected. And the notice of motion was issued on 2 August 2017. Only notice of motion was issued, Lord, no interim protection, Lord. In view of the fact, possibly in view of the fact that exam is already over. And so it is not similarly situated with Tulika Bharati's case. Tulika Bharati was granted 1-year extension in 2016, but the writ petitioner has come after 1 year when the entire exam is over. And she has not filed any petition for early hearing. For last 8 years, she has kept mum.
Yes, Mr. Sharma, why you have not mentioned the matter earlier?
Lordship, on the last occasion, I said, Lordship, MS U Das was conducting this matter.
Who?
U Das, Lordship, Usha Das. Now she was empaneled as a government advocate. Probably that was the reason why this matter got lost, Lordship. As in when the petitioner approached me, Lordship, when she came to me, Lordship, I filed my wakalatnama and I appeared, Lordship. Earlier, my senior was there, Lordship. And Lordship, with regard to my friend's submission with regard to that 2012 notification, Lordship. Herein, probably, Lordship, the registration is, Lordship, that is undoubtedly of 22/9/2008, Lordship. And this law came in 2012 only, Lordship. Can this have a retrospective effect upon this registration, Lordship? That is one aspect, Lordship, if Lordship goes
The
into
law
it.
came into force on?
In 2012, Lordship, that notification that my friend referred to, Lordship.
But Tulika Bharati is based upon the notification.
Mr. Kogan, let him complete.
In Tulika Bharati's case, the earlier law which prevailed at that point of time was taken into consideration. In fact, both the laws were taken into consideration, but that law was applied, Lordship, that earlier notification. And with regard to that similarly situated thing, Lordship, herein in the judgment itself, it has been referred that she appeared in the BALLB examination in January 2009. Now this mark sheet I am producing, Lordship, herein that examination, he has also appeared in January 2009 only, Lord. My submission would be exactly similar, Lordship. The same batch, same course, same university, Lordship. Law would not apply differently, Lordship. Get an idea.
Okay. Yes, Mr. Kogan.
Milord, I don't know about the contents of that, Milord, notice or.
This is the one mark sheet.
Anyway, Milord, if we come to the vital aspect, when the entire exam is over and the registration was done, after the exam was over and the notice of motion was issued in the next month, on 2nd August, no interim protection was given.
No, it does not mean that we will refuse relief after final hearing of the matter. Maybe on the motion day, no interim relief was granted to her.
Well, in the meantime, Milord, entire syllabus has been changed, Milord. So
Maybe.
Milord, if we apply this Tulika Bharati case judgment, then also, Milord, already she has missed the bus, Milord. Since, Milord, it is to start from 17 June. And she filed this petition on 28 June. And the registration was done after 1 month, 31 July. And notice of motion was issued on 2nd August, when the entire thing is over.
We'll see.
So, Milord, that aspect is a very crucial aspect. If my lord, a representation may be preferred to the vice chancellor, still my lord.
Pardon?
Regarding my lord, considering our case.
No, there again, without any consideration, you will reject the same and the petitioner has to approach this court again.
My lord,
And another 2 years or 3 years will go.
my lord, we are still in dark about the candidate, my lord, about the petitioner. My learned friend has been asked by this honorable.
No,
mean, again.
you have received a copy of writ petition. There, all the particulars are available.
My lord.
Heard Mr. MP Sharma, learned counsel for the petitioner, and Mr. P.J. Pupon, learned counsel for the respondent. Argument concluded, order reserved.
Obliged, Lordship. Item number 6, Parhat matter.
May it please your lordship. In this matter, my learned colleague, Mr. P.K. Bora has sent the affidavit for waiting lordship. So lordship will fix the matter after the lordship. For your lordship's convenient lordship, we will file affidavit. Mr. P.K. Bora's name may be recorded. He is on dictating court number 2 lordship. So he has already sent for waiting.
Okay. Madam?
Your Lordship, the thing is that the government has been taking time again and again. So if this time it is finalized.
Heard Miss S. Sharma,
Yes.
learned counsel for the petition. And Mr.
P.K. Bora, lordship.
Mr. Sharma, P.N. Sharma, learned counsel appearing on behalf of Mr. P.K. Bora, learned standing counsel for the respondent number 120. And Mr. P. Sharma, learned counsel for the respondent number 6 and 8. 6 and 8. Mr. Sharma submits that Mr. P.K. Bora has already prepared the affidavit and sent the same for vetting and will be filing within 1 week from today. Within 1 week from today. Accordingly, he prays for granting some time. There is accordingly allowed places is the matter. After 1 week, enclosing the affidavit to be filed by Mr. P.K. Bora, learned standing
Your
counsel
Lordship,
for the
kindly a date may, Your Lordship, kindly a date may be given.
next week may not be possible. In the second week of June.
Second week of June.
Yes.
On 11 June.
Right.
Item 7, Parhat matter.
There was a direction to file an affidavit. In fact, last opportunity was given, but we have said for waiting, we have to take two more days to file the affidavit.
2
more days,
2 more weeks.
not weeks, but days, next week, so this Friday. By Wednesday, I'll file it. I've already set it for meeting.
Bora,
My lord,
Okay.
heard Mr. D. Bora, learned counsel for the petitioner, and also heard Mr. D. Pegu, learned standing counsel for the respondent number 2 and 6, and Mr.
And for elementary department.
Mr. Sharma, P.M. Sharma, learned standing counsel for the respondents at elementary education department, and Mr. R. Boro for respondent number 7. Mr. Gogoi? 8. 8. Mr. Pegu, learned standing counsel for the respondent number 2 and 6, submits that he has sent the affidavit for vetting, affidavit in opposition for vetting, and price for listing the matter after 2 weeks. Parallel, list the matter on 16 June.
16.
16 June.
Meantime, we have filed our exchange our replies, madam.
Okay. In the meantime, Mr. Pegu shall furnish a copy of the affidavit in opposition to Mr. Bora. Mr. Bora is granted the party to file reply to the proceed affidavit.
Other affidavits also, all the affidavits will file reply.
Okay.
In the meantime, madam.
Okay.
Item number
Obliged.
8, Parhat matter.
Yeah, Lordship, here as per last order, we are asked to file an additional affidavit bringing on record to provincialization orders of two of the schools. So Lordship, today only we could file it, Lordship. So,
Today.
yes, Lordship. Lordship,
Okay, after 1 week then?
Yes, Lordship may fix it on 29th, probably just
On?
29, Lordship, next Thursday.
9. Okay. Parthard matter. So it is Parthard matter or after in the second week of June. Heard me, sir?
NZ Chaudhary.
NJ
Chaudhary.
Chaudhary, learned counsel for the petitioner, and Ms. Terapy for respondents in elementary education department, secondary education department. Mr. Chaudhary, learned counsel for the petitioner, submits that we will be filing the reply to the affidavit in opposition today. That price for listening the matter after 2 weeks, fair allowed, this is the matter on
13.
Apply that.
Item number 9, department matter.
May I plead, your lordship?
This matter.
Huh? Oh, it was a final. Disposal of
After some time, lots of Mr. NJ Khatonier is there in this.
directed to
On
give
behalf
some
of-
instruction.
Pardon?
NJ Khatanier was directed to produce some instruction.
Standing.
Okay, after some.
Item 12, department matter. Well. 12.
Why not? Maybe, so that's. Lordship. Dada, 12 to Madras. 12. Why not? 6 9. Sorry, sir. Sorry, my lord.
May it please, my lord. The matter was posted for final consideration. My lord would kindly peruse the third last order passed by this honorable court. That is my lord's order only. My lord has heard the matter at length, my lord. My lord, may I kindly start, my lord? May I start, my lord? Matter is basically regarding the fact that my date of birth was wrongly recorded, my lord, in my HSLC certificate, because of which, my lord, my pension and other pensionary benefits have been withheld till date, my lord. My lord, my actual date of birth is 1/7/1962, but the respondent authorities say that my date of birth is 1/7/1960, and because of that, I have overstayed for a period of 2 years. And on that count alone, my lord, my pension has been withheld.
Mr. Sharma, the respondents are available.
What's it?
Who are appearing for the state,
I am from the elementary department. Not.
you are elementary.
And I'm not really preparing for the finance.
Finance was impeded by recently. But we have total later, but my instruction is everything. Because we have been impeded on 31/7/20 in the petition. Sometime I will let the instruction because we have been impeded.
And here, in fact, the SEBA is also.
31/7/24.
They are also to be.
No, you are appearing for finance department.
Yes. On 31/7/24, the finance was impeded as a party. Vote proceeding.
My lord, may it please, my lord. My lord, on earlier occasion, my lord, my learned friend from finance department, Mr. Soliha, had said that main role lies with the elementary education department. An affidavit has already been filed by the elementary education department. That is why it could be taken up today, my lord, for consideration. I have been suffering since the last 2 years, my lord. That is my grievance, my lord.
Lordship matter.
Only if it-
pension. So without hearing Department of Finance, Lordship, perhaps, because it is a matter pertaining.
My
to-
lord, I was
the
verbally
pension.
informed that the records are with the elementary education department.
We have filed our affidavit.
That is on record, my lord. It can be taken up for adjudication, my lord.
Mr. Gogoi, your part is limited here.
That is all. Because let's say we are. They will be. Because now there is a written instruction together. Because we have got
Yes,
some
my lord.
instruction.
I was verbally
He will
informed.
come. He will.
Okay, you will inform Solia. Okay, after some time, let Mr. Solia come.
I am deeply obliged. I am deeply obliged.
Item 13, department matter.
After some time, Mr. Esbora has some instruction. He's
As per, okay.
Item 15. Department matter.
Yeah, please, for lordship. Lordship, the last location, lordship, instruction was short for lordship. Instruction was short for lordship, last location.
Over, Mr. Musari. Miss Musari. E Musari.
M. Musahari is appearing in this case. D. Musahari.
After some time.
After some time.
Master.
Attempt 16.
Yes, sir.
Lordship, the instructions are awaited, your lordship.
My lord, earlier several times, lordship. Time. One last chance, my lord.
So, madam, you have been given sufficient opportunity
Yes.
to file your affidavit.
No, sir, not for affidavit, we were asked to place the instructions, your lordship, regarding his appointment, your lordship, because due to non-retention of the post, he has not been appointed, your lordship. So, proposal was sent from the director, your lordship, that there is a post vacant in the state school, your lordship. And if he can be adjusted in the school, that.
No,
proposal
that's all
was-
right, but I pursue the matter.
Lordship. Lordship is taking time because, your lordship, due to non-retention of the post, your lordship, the thing has to go to the finance, your lordship. The finance has to give the, we have to take the, opinion of the finance conference has to be given, your lordship. That's why we are taking some time, your lordship. And in fact, your lordship, on the last occasion, your lordship, the government had, inquired from us whether there is any retention of the post, and we had given the reply that there is no, there has been no post creation, your lordship. So now the government has to, give some information on that issue, your lordship. That's why it's taking some time, your lordship.
No, that's all right, but what is this? The file is pending. You can obtain the instruction to that effect.
Lordship, I have been, like, they are, asking for some time, your lordship. Because verification has to be done in the field level, your lordship, whether there was any post creation or not. Lordship,
Or
you want
Mr. M.
some time?
Learned Counsel for the petitioner and Ms. Sorry, Learned Standing Counsel for the respondents in Secretary Department. Ms. Musari submits that instructions are still awaited, but it appears from the record that several opportunities have been afforded to Ms. Musari to obtain her inspection. Accordingly, last opportunity is afforded to Ms. Musari to obtain her inspection, and in the event of failing to obtain inspection on next date, the court will proceed to hear and dispose of the matter without her inspection. Place the matter after 2 weeks.
Any date in the month of June, lordship, 9 or 10 or 11? 16.
Lordship.
Apply.
Item number 16.
May please, your lordship. This appeal is against the, my lord, judgment and order dated 18/2/25, passed by the learned Railway Claims Tribunal, by which, my lord, my claim application has been rejected, my lord. Though, my lord, the learned tribunal held that the disease had a, my lord, valid ticket, my lord. But I could not prove the train in which the untoward incidents took place, my lord. In fact, my lord, the my claim petition is based on the, my lord, inquest report as well as the final report submitted by the investigating officers, my lord. So that part, my lord, to my lord examine, my lord. Page 36 is the, my lord, improved note.
36.
My lord.
Okay, let notice go. Record come.
My lord.
Heard Mr. R. Sharma, Learned Counsel for the appellant. This appeal under section 23 of the Railway Claim Tribunal Act 1987 is directed against the judgment and order dated 18/2/2025, passed by the learned member within the Judicial Railway Claim Tribunal, Guwahati, in OA number Roman 2 U-01/2020. It is to be noted here that by the impugned judgment and order dated so and so, the learned member Railway Claim Tribunal Guwahati has dismissed the claim preferred by the appellant hearing. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated 18/2/2025. Admit issue notice to the respondents returnable and 4 weeks step be taken by registered post with ADN also by usual process.
All
Never
my lord.
come today. How
All
about
my lord, they have it.
no formal notice is required to be issued to Miss Eva for
And for the NF Railway. Union of,
formal.
Only one.
Union of,
Okay. However, no formal notice is required to be issued since Miss Bukam learned standing council, standing council
Central
for
Government Center. Central CGC. or not.
CGC entered appearance and received notice. However, extra requisite copy of the petition will furnished to her during the course of the day. The shall call for the record from the learned tribunal. This is the matter of the verdicts.
Standing item 12. Item 12. Our instruction is already placed in the court's record. Though we have a minimum rule, otherwise, one of the issue remains, there is some dispute regarding the date of birth of the petitioner. Lordship will find it, my lord, in the writ petition itself. The Lordship may kindly see, my lord, page 5, para 4 of the writ petition.
Page number?
Page number 5, para 4. Petitioner's own statement, my lord. Petitioner has preferred it. Has stated the reference to the letter the petitioner's original SSLC certificate was called for and was to be submitted for verification. The petitioner had stated that there was discrepancy regarding his age on the admit card and the SSLC original certificate. Further, he had stated that on so and so he had submitted an affidavit before the block elementary education officer stating that he had stated that he be allowed to superannuate as per the age of his admit card, which is why he had to wrongly retire on so and so. Further, the petitioner states that he came to know that he had superannuated not according to the admit card but as per his SSLC certificate. As such, the petitioner had annexed the original certificate of SSLC along with the photocopy of the same before the authority. But in order to ascertain this particular discrepancy in two certificates issued by the competent authority, it is the SEBA hearing, my lord, we will have to clarify. And for that, my lord, if they got the clarification, then
SEBA has clarified. They have also filed their affidavit.
My lord, Seva.
It has been stated that 1960 is the actual data as per the SEBA report. That report, SEBA has also filed their.
My lord, may kindly have page 98, which is the.
Let them complete.
Yes, please.
We have discussion in our affidavit. Lordship, I take up my affidavit filed by the Lordship. Respondent number 4. Page
Yes.
number Lordship. Affidavit is start from page number 58. Lord, may I take a Lordship to paragraph number 6, page number 60, Lordship.
Paragraph number?
Paragraph number 6 of the affidavit filed by the
Respondent number 4.
respondent number 4.
Yes.
Lordship, that with regard to the statement made in paragraph 2 of the writ petition, the answering given and gets twisted that the petitioner joined in so and so in 1911-1991. He then block elementary education officer South Block Harupathan sent a retirement notice to the petitioner on 1/6/2020. White letter number so and so stating that as per service record, his date of superannuation is 31/7/2020. Accordingly, he was asked to hand over the charge of the school to the next senior most assistant teacher along with all other documents in forenoon of 31/7/2020. But the petitioner, through an affidavit, an application dated 27/7/2020, had assured the BEO South Block Swarupadhar that the original HSLC pass certificate issued by the SEBA is as on 1st March 1979 has been wrongly recorded as, he has stated that it has been wrongly recorded as 18 years, 18 months in place of 16 years, 18 months, and he undertook that he would be responsible for any discrepancy that may arise due to his date of birth in future, and continued his service till 31/7/2021. Now, Lordship, may I take your Lordship to the annexure, Lordship? Page number
66.
Page number 69, Lordship. Page number 69 is the translated copy, the undertaking given by the petitioner, Lordship. And the vernacular copy is page number 70. Page number 69, Lordship, that it has been addressed to the block elementary education officer, letter number so and so, dated so and so. With due respect, I beg to state that as per your office letter, I have been asked to go on retirement on 31/7/2020. But in my SSLC admit card and pass certificate, and in all documents in the office, my date of birth is recorded as 1/7/1962. It is a fact that my date of birth is 1/7/1962. In this regard, I have submitted an affidavit. I hereby clarify you that the date of birth recorded in my high school certificate issued by the board is not correct. The date of birth recorded in admit card is correct. I therefore request you to allow me to continue in service till 1/7/2022 and oblige. There will not be any discrepancy in my date of birth, and I will be responsible for any discrepancy. This is my humble prayer. This was the letter given by the petitioner, Lordship. Now, may I take your Lordship to paragraph number 7, Lordship, of my affidavit, Lordship, page number 61. With regard to the statement made in paragraph 3 of the writ petition, the answering defendant humbly begs to state that the district elementary education Golaghat had asked the petitioner to provide the original SSLC pass certificate to verify his actual date of birth, as two different date of births were found in the SSLC admit card and SSLC pass certificate. Paragraph number 8. With regard to the statement made in paragraph 4 of the writ petition, the answering defendant begs to state that in order to confirm the actual date of birth of the petitioner, the district elementary education officer Golaghat on 13/3/2022 had sent the SSLC pass certificate and the admit card to the chairman SEBA Assam. And in reply, the SEBA white communication dated 22/3/2023, Annex 3, Lordship, confirmed that the actual age of the petitioner being 18 years, 8 months as on 1/3/1979, which means the petitioner attained the age of superannuation on 31/7/2020. Now, Lordship, may kindly peruse the Annex 3, Lordship. Annex 3, page number 71, Lordship. This is a reply from the, this is a letter from the department to the chairman, Board of Secondary Education, Assam, and 72, Lordship. Page number 72, Annex 4 is the letter from the SEBA. So and so, from so and so, Board of Secondary Education to the District Elementary Education, verification. Your letter number so and so, so and so. With reference to your letter cited above, I am directed to inform you that the information regarding age of Narendranath Barua sought by you by your letter number under reference number 7 is furnished below as per the record of this office. Therefore, Lordship, Narendranath Barua age, Lordship, may kindly peruse 18 years, 8 months, 0 days as on 1/3/79, which means he attains the age of superannuation, Lordship, on 31/7/2020, Lordship. As against the claim of the petitioner that his date of birth is 31/7/1962.
1/7/1963.
But it is 31/7/2020 as per the report of the SEBA. Now, Lordship, there is another claim of the petition that with regard to the statement, paragraph number 9, Lordship. With regard to the statement made in paragraph 5 of the writ petition, the answering tribunal begs to state that subsequently on 25/4/2022, the block elementary education officer South Salmara so and so sent a retirement notice to the petitioner because of the act of misleading with malified intention on the part of the petitioner by giving false undertaking and an affidavit on 27/7/2020. Paragraph number 10, Lordship, with regard to the statement made in paragraph 6 of the review, the answering tribunal explained that the block mission coordinator provided a non-liability certificate to the petitioner only for the SMC account and midday meal account operation related issue, but not on the basis of teacher's salary or age related issue. However, the said certificate was cancelled by the BEO South Salmara Golaghat on 2/5/2023. Your Lordship will find in page number 73, annexure 5. The non-liability certificate, annexure 5, Lordship. Non-liability certificate issued by this office under memo number so-and-so are hereby cancelled with immediate effect due to his liabilities of excess salary received by him with effect from 1/8/2022. This has been cancelled off. Now, paragraph number 11, Lordship. With regard to the statement made in paragraph so-and-so, the tribunal begs to state that the petitioner himself admitted on 27/7/2020 that there is a discrepancy in his date of birth in both SSLC admit card and SSLC original pass certificate, and thus prayed for continuing in process of pension on the basis of the date of birth recorded in the SSLC pass certificate, because of which the DO Golaghat communicated a letter number so-and-so dated so-and-so to the petitioner stating that there is no similarity in the date of birth of the petitioner in his Aadhaar, PAN card, SSLC pass certificate. He was claiming that in all the other documents his date of birth is recorded as 62. These are the documents where there is a discrepancy. But till date, the petitioner has not replied to the DO Golaghat, and consequently his pension proposal could not be processed by the office of the DO Golaghat. Since the pension related works are done online, it is not possible to proceed if there is a dissimilarity in date of birth in the documents provided by the applicant. Further, it is to be mentioned here that the petitioners have misled the office and already overlisted for 2 years from his actual date of superannuation. So he had excess drawn his salary for 2 years by misleading the office and malified intention. Hence, the excess drawn amount will be recovered from the petition. In this regard, also, I will place
citation
orders of the judgment of this honorable court lawsuit. Therefore, lordship, with regard to the petitioner admitted. Therefore, paragraph number 12, lordship, in regard to the statement made in paragraph the that the petitioner misled the office by submitting wrong documents, and accordingly he has made overcharged his duties for 2 years and excess salary also drawn from the government exchequers, and due to the discrepancy of his date of birth, it is not possible to process his pension and pension benefit. Therefore, lordship, my humble submission is he has not come with a clean hand. He has done all this with malified intention, lordship. The lordship will find the affidavit filed by the SEBA also, lordship. They have clarified.
Who is appearing for SEBA?
My lord, may I just say something?
Wait. Yes.
My lord. Affidavit has been filed by SEBA, my lord.
SEBA.
Yes, my lord. At page 97, my lord would find, and SEBA has also given their stand on this issue, my lord. If I may just read for a moment, my lord. My lord, may kindly have page 98, my lord. 98 for a moment, the bottom portion, my lord. Particulars of a candidate, if I may read, particulars of a candidate, including date of birth, age, are preserved in the office record, MRS and TR. And on the basis of these particulars, HSLC pass certificate are issued. In the board's record, MRS and TR, the age of the petitioner is found as 18 years, 8 months as on 1/3/79. Hence, the board has rightly recorded the age of the petitioner as 18 years, 8 months on 1/3/79 in the pass certificate. Regarding the admit card, it is to clarify, next page, my lord, 99. It is to clarify that during that time, admit card were being written in school level and there was maximum probability of wrong recording. Probability, my lord. They have not said that it is wrong. My date on the date of my age, the age recorded in my admit card is wrong. They are saying probably it was wrong. Now, my lord, should I suffer because of their wrong? They are now saying that it is probably wrong. And my lord, if there was such discrepancy, they should have conducted an inquiry under Rule 21 of the Assam Pension Rules. There is a rule, my lord. There is a procedure that has been followed. You tell me you work. I gave them a reply. They allowed me to work. They kept mum, my lord, the authorities. Now, after
No,
2 years, they
uh,
say that I have
The
overstayed.
authority has issued one notice to you.
Yes, my lord. Yes,
For retirement.
yes, my lord. I would also like to draw the
But,
honorable
you have given your undertaking that the age mentioned in your certificate is correct.
in my admit card
admit
is
card
correct.
is
my lord.
correct.
Yes, my lord. I've given my lord. And my lord, one more rule I would like to point out that I've given, my lord. That is an admitted position. My lord, under Rule 95 of the pension rules, it says that 1 year's time may be given to the person who is retiring. I got the notice from the respondent authorities on 1/6/2020, telling me that I should retire in a period of 1 month. 31/7/2020, I should retire. If my lord has paid 66 for a moment, which my learned senior had referred to some time back, the affidavit filed by them. On verification of your service book and as per letter number so and so dated 31st October 2012, issued by the Commissioner and Secretary Government of Assam, your date of retirement falls on 31/7/2020. My lord, just 1 month or 2 months before, my lord. My lord, may kindly have the Assam pension manual for a moment, my lord. Rule 95. Rule 95 categorically states that 1 year's time may be given because, my lord, there are a lot of formalities regarding pension. My lord, it cannot be done in the whims and fancies of the responding authorities.
You have referred to rule.
Rule 95, my lord, would kindly have. Rule 95. May I read, my lord? My lord may have it at page 47, my lord, of the pension manual. May I read, my lord?
Yes.
Procedure. With a view to ensure completion of pension records and documents in time to avoid the possibility of any delay in the commencement of pension, each head of department and office or the administrative department, where there is no head of department or office, shall have a superannuation statement prepared on 1st of January in each year. 1st of January, my lord, showing a list of all officers, gazetted or non-gazetted, who will attain the age of superannuation in course of the next calendar year, between 1st of January to 31st December next year. As soon as the list is prepared, an intimation should be sent to every such officer due to retire during the next year, drawing his attention to his anticipated date of retirement and the provisions of Rule 184 to 188 to enable him to make a formal application for pension 1 year in advance or 1 year in advance, my lord, of the date of his anticipated retirement. This list should include the names of the officers who are on temporary deputation to other department, government, on foreign service, and intimation should similarly be issued to such officer as well as the head of the department or foreign employer. If no intimation is, however, issued to the officer, this shall not in any way change his date of retirement and shall not confer on government servant any right to remain in service beyond the date on which he is required to retire. Now, my lord, 1 year, they should have intimated it, my lord. This rule categorically says that 1 year intimation should have been given to us. Moreover, my lord, I would like to draw this honorable court's attention to Rule 21 for a moment, my lord. If my lord has Rule 21, page 10, my lord would have the pension manual.
Yes.
The governor of Assam reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for specified period, and the right of ordering the recovery from a pension of the whole or part of any pecuniary loss caused to the government. If in a departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon re-employment after retirement, provided that such departmental proceeding, if instituted while the officer was in service, whether before his retirement or during his re-employment. Now, my lord, the explanation part is important, my lord. Would kindly have. Powers under Rule 21 shall be exercisable not only in case of causing pecuniary loss to the government, but also in other cases. Such departmental proceeding, if not 21, such departmental proceeding, if not instituted while the officer was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the Governor of Assam. Shall not be in respect of any event which took place more than 4 years before such institution. Now, my lord, 4 years before this institution, cause of action had arisen. The responding authorities did not conduct any inquiry whether my age is wrongly reflected. There is in fact an order of this honorable court 29/5/24 which states that whether they had conducted any inquiry or not, the responding authorities. They have not, my lord. Now, my lord, post-retirement, they want to take a benefit of their own wrong. My lord, in fact, there are judgments passed by the Honorable Apex Court and this Honorable Court which state that, my lord,
Mr. Sharma.
Yes, ma'am.
They, after inquiry, they have issued the notice to you
My
that
lord,
you are
fine.
supposed to retire on such and such date.
That inquiry report should have been furnished to me, my lord, and it is against the principles of natural justice. That should have been provided to me. There should be a basis.
And also in so far as the issue of notice of 1 year loss, which is primarily for the processing the pension papers and documents loss. Now, in this case, he is the lordship, kindly see lordship. He is the headmaster at the relevant point of time, and he is the custodian lordship. Even his service book is with him. May I place the service book lordship? No, lordship. And he is also DDO.
My lord, in my service book, my right age
He
is
the
recorded.
headmaster at the relevant point of time. Lordship, kindly, where is these two letters? Like my lordship?
So is it part of the?
Yes, my lord, it is a part of the writ petition as well. My lord, may kindly have page.
Please perhaps on the last two.
My lord, page 32 of the writ petition, my lord, 32 and 33. It is there, my lord, part of the annexures now. And there, my lord, there is a correct recording of my date of birth, my lord, 1/7/1962. Page 33, my lord.
He being the headmaster, the dealing and disbursing officer, the custodian of the service book. And he doesn't know his.
No, my lord, I know that is why it is 1/7/1962, my correct date of birth. My lord, then they should have sent the notice 2 years
No.
ahead, 2020, not in
This,
2022. 1 month
There
before
is,
my retirement.
there is overwriting.
Where is the overwriting also?
My lord, in 7, my lord, 7.
So the service book you have a license record is appears to be not the service book which Mr. Soma has submitted today.
My lord, this is the service book I got, my lord, from my client, man. Page 32 and 33.
In that case, let me place the original service book. Also.
There is manipulation. In the service book which you have enclosed with the writ petition.
My lord, perhaps my lord is referring to point number 6, my lord, if I am not wrong. Point 6 of the page 33.
Seven, point number 7.
7, my lord, is 1/7/1962, my lord. It is categorically written, my lord. There is no manipulation.
No.
6, my lord, there is a.
In the service book filed by him, it is 1/7/1960.
But my lord, this is what I got, my lord, 1/7/1962 from my client. This might have been done by them later on, my lord.
Oh,
The responding authorities. Now they are the
your
custodian.
service book, it is in
No.
your custody.
No, my lord.
Mr. Soma, you see, you are not approaching the court with clean hand.
Clean hand. Lordship. That is what my submission is, lordship.
My lord, this is the.
You see this service book produced by him.
My lord, my service book is now with them, my lord. Original. Yes, my lord, because they have striked it off. It was 1/7/1962. My lord may kindly compare it with the writ petition. Later on, this has been done.
Who
This has
did
been
it?
done by the respondent. I did not do it, my lord.
No, it was in your custody, being the
My lord, it
headmaster.
was in my custody till the date I was there in service. Then it is with them, my lord, now. Since my
Yes.
pension has been withheld,
Let me
the
press
cutting has
original-
been there.
Let me press the original service.
Then, my lord, I will also press the original one, my lord. Because, my lord, my client had provided this, my lord. Oh, sorry. My lord, I can also call my client to bring the original, because there was no cutting in
Where
the.
do you got it?
Lordship, on the last two in the Bharat, my learned colleague, Mr. P.K. Bora was arguing the matter. Previously, Lordship.
My lord may kindly have this also, which I
You
got.
produce the original one.
Lordship, original service would be required, Lord.
My lord, I have one more copy, if my lord would kindly peruse. There is no cutting in that, my lord, but subsequently this has been done by the responding authorities. I can also tell my client, my lord, if he has another copy of it.
Heard Mr. Pierre Sharma, learned counsel for the petitioner, and also heard Mr. P.N. Sharma, learned standing counsel for the respondents in elementary education department. Mr. Gogoi for finance department. Mr. Bora for Seva. Respondent number 9, and Mr. Bhattacharya for respondent number? Respondent number 3. Heard in part, list the matter on 18 June. In the meantime, Mr. Pierre Sharma, learned learned counsel for the petitioner, and Mr. P. Sharma, learned standing counsel for the respondents in elementary education department, shall produce the original service book of the petitioner before this court.
Item number 17.
Deeply obliged.
List the matter as part.
My lord, this is an appeal against the injunction order, my lord. The losses can take up the IA, my lord. Where I had, my lord, here, the suit was filed for partition of 3 big kathas of land. But saying that, my lord, that the other lands were already divided. My lord, but this land was already, my lord, along with other land, it is divided. And the opposite party number 1, the plaintiff, he got more land, my lord. I have given the detail, my lord. If your lawsuit will come to, my lord, page 121. He is occupying, my lord, 4417 square feet of the land out of the 8,640.
$121.
121, my lord. Thanks.
Yes.
My lord, the total land is, my lord, if you also see, lot 3, it is 8640 square feet, 3 katha, out of which R.N. Pathak, the respondent number 1, my lord, he occupying 4417 square feet. So I am occupying only 3251 square feet. Photographs also I have given, my lord, here. Next page 122. So, my lord, he said, my lord, because of my son's, my lord, marriage, which is fixed on 15th of June, my lord, I am making some construction, my lord. At page 115, if you also see, my son's marriage, my lord, invitation card is there, that he is going to be married on 15th of June. So, he had made a false statement, my lord, in the as well as the intimation. I shall come to that, my lord. If your lordship will see, my lord, his, my lord, at page 34 of his petition, my lord. First 32, my lord, para 10, your lordship may see, my lord. 32, para 10.
Yes.
Yes. Petitioner was curious as to what construction opposite party number one planning to undertake. The petitioner repeatedly asking the opposite party number not to raise any new construction since standing structures were pretty old. However, to utter surprise, the petitioner, the opposite party number one, in the third week of April 25, he started raising new construction of a small vacant land measuring 20 feet by 50 feet between RCC building and southern boundary wall, and also a portion of the land 15 feet by 12 feet behind the other rooms. My lord, here he has annexed, my lord, a photograph, my lord, if you also see at page 51, my lord. Some photographs are same there. The photographs, if you also see, photographs were taken on 5/2/25. If you will also see in the pilot, Guwahati Zoo Road, 5/2/25 at 5:30 AM, my lord, in the morning. Okay, these photographs were taken. All these photographs. Prior to that also, my lord, some photographs are there. All photographs are taken. My lord, falsely, my lord, stating that, my lord, yeah. My lord, now, here what happened, my lord? The petitioner has already, my lord, my present status of the construction is, my lord, if you also see at page 116211, my lord, 119 may be seen, my lord. Already at the time, my lord, roof, my lord, placing, he is placing the roof, my lord. 1152, 116 to 119, my lord. At this portion, my lord, falsely filed a suit, my lord, he is saying that in the third week of April, I have started, my lord, which is absolutely on the face of it is false, my lord. My lord, so far this is concerned at my lord, weeks and cost, my lord, I may be allowed to complete this, my lord, roof, my lord. My son's marriage is fixed on 16th, my lord. My lord, he will not suffer, my lord, anything because he is occupying more land, my lord. I can place, my lord, because he himself, my lord, lease out some, my lord, house, my lord, saying that I am the owner of the. That lease agreement is also here, the next, my lord, at page 46, my lord. This is the lease agreement given to somebody else, my lord.
Let us first admit the appeal.
Admit appeal, my lord, only thing, my lord, I may be allowed to complete my roof, my lord, because my son's marriage is on 16th, and I shall not.
Heard Mr. Lian's learned new counsel assisted by Mr. So. Learned counsel for the appellant this appeal under order 41. Order 43, rule 1, certificate R. With order 43, rule 2 of the Code of Civil Procedure is directed against the order dated 8/5/2025 passed by the learned civil senior division number 3 and case number 425 of 2025 arising out of title suit number 280 of 2025. Is to be
already
interpreted
looked up
by
to-
the impugn order dated 8/5/2025 the learned court below has granted injunction.
Yes, my lord. That is at page, my lord, 17 onwards, my lord, and the operative portion is at page 21. my lord. Abstain from the yes. The other things, my lord, all allegations are false. And that portion of the construction I have shown, my lord, in my photograph. If you are also
Staying further construction work over the suit land, schedule A land. Whereas the memo of appeal and the grounds mentioned there, let notice be issued to the admit. So notice to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process. Then I will conclude it. This is the matter after 4 weeks. In IA, after going for the record, I will pass out.
my lord, only thing, my lord, if you are also just see page 122.
Yes.
This construction, my lord, this is the construction going on. The portion, my lord, I have already shown the what construction stage is there, because this left-hand side bottom, my lord. The stock construction, this is the portion only where I have making construction. The other portion, my lord, he is occupying. Maximum portion he is occupying, my lord.
Okay.
My lord. So only, my lord, thing is this, my lord, at my risk and cost, my lord, I may be allowed to complete that, my lord, roof, my lord, construction and other things, my lord. I shall not construct any other further, my lord, construction, my lord, first floor or second floor, my lord. Because at this stage, it will create my difficulty to my son's marriage also, my lord. Because for my son's marriage, my lord, I have required some additional space, my lord. That is why I have done it. And this, if it is remain as it is, my lord, it will create more difficulty, my lord. Because bamboos and other things are all this.
Standing item 30.
Maybe Lordship. Lordship, on the earlier date, Lordship, my learned was directed to take instruction with regard to page number 22, which was subsequent to my regularization order, Lordship.
Mr. Bora?
Not fair. I have to go the instruction, my lord. But that particular file of Nagaon, that could not be located where he was, once he was appointed as a laboratory assistant, thereafter how come he become LDA come typing?
That file is not available.
That file from Nagaon is not been traceable till date, my lord.
The post of laboratory assistant was regularized, Lordship.
Then how come next after that, my lord?
Again, temporarily appointed, Lordship.
That's why the temporarily appointed. Thereafter, my lord, what my friend is challenging the order dated. What will find that order? That also makes it clear, my lord. Order dated 4/9/2013.
No, Mr. Bora, you tell me, is there any possibility of tracing out that file?
Trying to look at because it's some office shifting has taken place during that period, money. That's why file could not be located. And in fact, my lord, my friend is challenging the order dated 4/9/13. There itself, which also makes it clear, my lord, that his service was ad hoc. That order itself says his service was ad hoc. And from that particular order, with effect from 27/3/2007, he has been regulated. So when it comes after 2005, my lord, particular date of 1/2/2005, my lord, he is not entitled to pension. He will come under the NPS. That is the issue, my lord. When the order we challenging, it's also making it clear, my lord. You are having ad hoc service, my lord, on that particular date.
Which order? Page number?
Page number 13. 30 is the type of it. Pursuant to government letter number so and so, dated 17/5/2010, which was conferred by the finance department, number dated 17/8/2006, and pursuant to Honorable High Court interim order with petition number so and so. He has annexed the petition also. Dated so and so, the ad hoc service of the following 32 employees, along with this petitioner, my lord, under the Director SCRT, are hereby regularized with effect from 27/3/2007 under new pensions rule 2005. He has been regularized with effect from, he was holding an ad hoc service, thereafter he was regularized on 27/3/2007. That's why when he comes.
No, whether the ad hoc period will not be counted or pensionary benefit.
No, he has been regularized from 27/3/2007, taking in consideration with the judgment, my lord, not with that, see the judgment, it's annexed, it starts from page number 30, and it has been mentioned. Then all this person, there is the judgment, my lord, that also has been noted down in the petition number 434/2013. Thereafter, after considering everything when they in the judgment, he has been regularized with effect from 27/3/2007. And that particular judgment is written in the.
At the very beginning, he was appointed as laboratory assistant.
Laboratory assistant, without any advertisement, without anything, that he has been then at very beginning, lots of people turn to the his appointment. That is also very interesting. Page number 15. subject to termination and without notice and assigning any reserve thereof, page 15. Mr. Sri Vinod Kumar Bora, the petitioner, an outsider, is hereby appointed on ad hoc basis as a laboratory assistant. No advertisement, nothing, in non-compliance of the Article 14, no advertisement was, he was from outside, he was been appointed.
With regard to advertisement and selection procedure, I have filed one additional affidavit, Lordship. My post was in due process of law, Lordship. There was advertisement and Lordship select list also, Lordship. I have annexed subsequently by way of one additional affidavit, Lordship.
Now let's will come to page number 22. Laboratory assistant, he was appointed on in the year 25 December 2091. 22, subject to termination without notice, assigning any without any reason thereof, the Vinod Bora, laboratory assistant hereby appointed temporarily as LDA cum typist in the scale of so and so. So he was again appointed in 31/1996 as a laboratory assistant type. How come this is as appointment, but that file particularly is not tested. That is the issue.
Now you tell me whether without that file we can dispose of this petition or not.
Look, if not with a chance, I will try, my lord, because in the same thing that order he is challenging, that's also make it clear on 4/9/2030, page number 30, that he is on that particular reason head of service. He's the resident regular, and then he was regularized with effect from 27/3/2007.
So the new pension will come into force with effect for
But new pension has come into
2005.
1/2/2005. First of February
2005. But you see, he was appointed in the year 1996.
There is no dispute with regard to this appointment, but my lord will kindly consider what was his nature of appointment.
Pardon?
Lordship will consider what was his nature of appointment. So the fact that he was appointed way back in the year
Whether because of his ad hoc appointment, his earlier service period will not be counted for
Yes,
pensionary benefit.
there is a direct Supreme Court decision on that point. I have mailed it. My lord, Lordship will kindly consider it. That was a matter, my lord, where the legal heirs, my lord, of the deceased employee, they claim, my lord, for grant of family pension. And admittedly, the person concerned, the employee, he was on ad hoc appointment.
No, this judgment may not help you because his service was subsequently regularized.
Regularized with effect from 2013 to 2007.
Seven.
Yes.
Yes.
So that-
But
that-
he was appointed earlier in the year 1996 as
Yes.
per his version,
Absolutely,
following due process of law.
absolutely, maybe, but he continued to be. a-
No, now the question is whether his past service period will be obliterated.
The Lordship got it. Yes, that's it. Now, his past services, for a moment, if Lordship comes to my lord, page 30 of the writ petition.
30.
30. This is the type copy.
Yes.
This is the order by which his services have been regularized amongst other employees. In pursuance of a decision pronounced by this honorable court, that decision has also been annexed to the writ petition. Then, Lordship, I am reading it, my lord, page 30. In pursuance of the government letter number so and so.
No, that's all right. As per order of this court, his service has been regularized
Yes, my lord, in the.
with effect from 27/3/2007.
Yes, Lordship will kindly see the fifth line.
No, now you
Yes, yes.
please answer my question of
My-
whether his service period as ad hoc employee would be not counted for pensionary benefit.
My submission will.
No, do you have any decided case on this point?
Yes, my lord, that is one. my
Which
lord.
one? No, this will not cover. This will not cover.
No, Lordship will kindly come, my lord, to paragraph. paragraph 30, my lord, 30. Paragraph 30. It is one thing to say that a person was appointed on a temporary post on a regular basis, but it is another thing to say that an appointment was ad hoc in nature on a temporary basis. Whereas in the former case, the appointment must be carried out in accordance with law. In the latter, it may not be. From a perusal of the offers of appointment as noticed herein above, it is evident that the appointments of the concerned employees were made for a period of 6 months till a regular appointment was made. Same case here, my lord. It was extended from time to time. The very fact that the posts were to be filled up on regular basis by the competent authority clearly goes to show that the nature of appointment of the said persons was ad hoc one. And thereafter, my lord, the honorable appellate court, my lord, negated the claim. They were asking, my lord.
No, in this case, the appellant, throughout his service, he was on ad hoc or temporary employee.
Yeah.
But here his service has been regularized.
Regularized,
So his services have been regularized.
Yeah.
Ipso facto, my lord, meaning thereby that on a.
No, therefore, the question to be decided is whether the earlier service period will be counted or not.
Earlier service, in my respectful submission, since he was.
No, I am asking you whether is there any decided case on this point or not.
To refine it, my lord, I can place.
Lordship, I also place lordship, there is subsequent judgment
But
passed by
here
the Honorable
that's
Supreme
not
Court in
very
Prem Singh
clear.
lordship. Prem Singh in paragraph number 36. And there is another one subsequent judgment that is.
Have you produced those judgments before the court? Do they not?
I will furnish Prem Singh and lordship Pratapalan Patwari is.
You
Really
produced those
protected my case, lordship.
I mean, they can sincere attempt to distinguish Prince, but he will produce, I hope.
And that is
Mr.
not.
Bora, in the meantime, you try to find out the file.
Paragraph number 20 of this
Here, lordship.
court order, lordship, which I have annexed, lordship.
Here, lordship, with all respect, we kindly consider Rule 31 of the Assam Pension Rules 1969. That is the crux of the matter. Rule 31.
31.
Rule 31. In fact, he will also admit, because Rule 31 is the basic provision which enables a person, my lord, to receive pension. There are three conditions. One has to be in substantive employment, my lord, and my lord, it has to be under a pensionable establishment, and then, my lord, the employee has to be paid by the government substantially. Now, all these three conditions, parametric provisions are also to be found in the state of Haryana statute. They are, my lord, pension rules. Therefore, Apex Court has relied on. Kindly see, my lord, paragraph 21 of that decision which I have just now given.
No, you tell me, which condition of this 31 is not fulfilled? There are
Every
three conditions.
condition fulfilled.
No way.
And the respondent already complied the court's order, lordship, by which the
second
order was set
condition-
aside, lord.
The second condition, my lord, is apparently have not been, my lord, fulfilled in the present case.
Second.
Second condition. The first condition is, my lord, the service must be under the government. Secondly, the employment must be substantive and permanent. This is where, my lord, the line of distinction here. Substantive and permanent.
No, now he is in permanent post.
Now he is in permanent prior to that. So therefore, principal kindly appreciate, my lord, he is not deprived of pension. He will get pension. Whether-
That's all right.
Yes,
If
no.
he is entitled to pension from 1996, from the very date of his appointment, why should we forego the same?
The lordship, that is why the
Okay.
rule 31, lordship. Rule 31 is for
Therefore,
declaration of past services, lord.
Okay, okay.
I will make a attempt.
Heard Mr. S. Talukar, learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel for SCRT, respondent number 2, and Mr. Porpuzari for the respondent number 3. Respondent number 3. Heard in court, list the matter on
16th June.
16th.
Lordship.
We'll resume after
So,
minutes.
For bail hearings, item 43 to 46.
My lord, I'm praying for taking it at home.
No, You can take time, but we cannot.
Then
We have some other matters.
my PP is also not here, my lord. Learned PP is. Otherwise, I can do also. PP is also not.
Next item.
Coming item 9.
I'm out.
Furnish a copy to her.
Yes, madam, I have already,
So after 1 week or 2 weeks?
2 weeks, madam.
After 2 weeks.
Yes, madam.
Lordship, may I submit, my lord? Admittedly, there is no dispute regarding the entitlement of the petitioner's dues, my lord. As the matter is under consideration, my lord, rather keep it pending, keep the matter pending, my lord. May be directed to the government to carry the whole exercise within a reasonable period of time. 2-3 months, my lord.
I have no objection.
Lordship, last few occasions.
So can we expect it within 1 month from today?
It's difficult to say, my lord, because already views from the finance department have already been obtained, my lord. Now it is in the departmental level only.
2 months,
So
my lord.
what is the view of the finance department?
That is not reflected here, but maybe positive reflect because they have not said anything that rejected, finance department rejected or something.
Okay.
Nothing mentioned in the communication.
And then after 1 month, we will see.
Yes.
Heard Ms. Bora, Learned Counsel for the petitioner, and Mr. Khatunian for the respondents in elementary or secondary?
Eliminated.
Elementary Education Department. Person to order dated 14/5/2025, Mr. Khatunian has obtained instruction and placed the same before this court. The result of the same indicates that the matter is being processed by the department concerned. After obtaining views from the finance department, Mr. Khatunian submits that the matter may be listed after 1 month, after 4 weeks, They are taking note of the submission of Mr. Khatunian and also taking note of the submission of Learned Counsel for the petitioner. It is provided that the SSL lays the matter after 4 weeks. After 4 weeks.
A date may fix, my lord.
Okay. The instruction placed on record today, placed before the court today, shall be part of the record.
26 to
Oblate.
timing 43 to 46.
Lord, in this case, my lord, I have submitted last day, my lord, that is judgment of one Azibur Rahman. My lord, here, the issue raised by my learned friend, the additional PP has been discussed, my lord, that is, I have referred, my lord, that is bail application number 624 of 25. Where, my lord, the paragraph, my lord, 5.1, page 6.
Yes.
My lord, bail application of our High Court, page 20, bail application number 624. My lord, here, I like to take my lord to paragraph 5.1, that is page 6, 5.1. My lord,
Paragraph number?
5.1. My lord, page 6. Below page 6 of 28. There are 5 points. My lord, what is? Where, my lord, the effect of Pankaj judgment, my lord, the Pankaj Bansal. My lord, here is it. May I read, my lord, paragraph 5 point?
Not necessary.
Then, my
it's
lord,
a-
paragraph 12.
say-
Paragraph 12.
Hmm.
Here, my lord, it's the honorable court says that the in state of page paragraph 12, next page, my lord. My lord, fundamental from top, my lord, fundamental rights has make whole paragraph of.
No, not necessary to read out the entire.
Mark, my lord, the apex court in the case of, my lord, state of Madhya Pradesh and Thobaram. Here it is reported in 1996. AIR 1996 SC 1910. Here paragraph referred, my lord, reproduced. Paragraph 20, 21 and 22. Now, my lord, I want to take, my lord, to paragraph 20. 22 of that judgment of the Honorable Apex Court, my lord. Paragraph 22. May I read?
Where is the original judgment?
My lord, that judgment, my lord, due to want
Not
of
available.
due to want of time, my lord.
So is there any guarantee that it was rightly quoted in this judgment?
My lord, this is, my lord, I have print out from our bar, my lord. This is bar library, my lord.
You produce the original judgment?
Then, my lord, paragraph 20 also says it has no relevancy. Then, my lord, after some time, I can produce that.
Pardon?
At 2, I can produce that, the judgment. I require some time.
Then not today?
Now, my lord, then judgment I will produce. I have also another order also here also discussed, my lord. It is also bail order passed on 5/5/25.
Of this court?
Not this court, or coordinate bench of.
That's all right.
Here also says.
You were relying on the, originally you were relying upon the decision of Supreme Court.
Supreme Court.
Show me the original judgments of the Supreme Court.
This my lord, I 15-20 minutes time I can take, my lord. Right.
What do you say?
After some time, my lord, within 15 minutes I am. My lord may give 15 minutes time.
Okay, we'll see.
I'm.
Next second.
For hearing under order 41, rule to 60, attempt 18.
Feel back. Okay, 10 minutes.
Attempt 18.
Yes.
The appellant is the defendant and counterclaimant before the trial court. He has purchased a plot of land measuring 1 kata 10 lecha by a registered sale deed, and from the same family, my lord, the plaintiff has also purchased 1 kata 5 lecha. Now, plaintiff files a suit for declaration of title and recovery of possession. And then I file a count. I was in possession. I file a written statement, then a counterclaim. That based on the sale deeds, I pray for a decree that my right title should be declared on 1 kata 10 lecha. Now, so far as plaintiff is concerned, my lord, plaintiff has relied on 3 sale deeds. One, his vendor's sale deed in his favor. Then another sale deed in his favor of his vendor. and another sale deed in favor of his vendor's vendor. Now, trial court has noticed that the exhibit 5, by which his vendor's vendor purchased the suit land, did not have any boundary. And that was about a bigha from 98 bighas of land. So naturally, it was not identifiable. This was argued, this was placed before the court, and in the cross-examination, PW5 has admitted also. Despite that, my lord, the trial court ignores that and says that no, plaintiff has title over the suit land. Lordship may kindly see the issues, my lord, at page 63. Page 63, my lord, the issues are framed. Page 63. Issue number 5 is whether the registered sale deed number so-and-so is illegal, invalid, and null and void and has not conferred any right, title, interest on the plaintiff. And then next is whether the plaintiff has right, title, and interest for the suit land. Now, this issue has been decided, and the discussion starts from page 67. Para 16, my lord. Being interlinked, these issues are taken up together, 5 and 6, my lord. For discussion and appreciation, plaintiff has claimed his right, title, and interest over the suit land on the basis of registered sale deed number so-and-so of 1999. According to the plaintiff, he had purchased the suit land by the registered sale deed and was also delivered possession thereof by the vendor. The plaintiff has traced his title over the suit land as follows. As per plaintiff, the original owner of the suit land was Tahirun Nessa, daughter of so-and-so and grandmother of pro forma defendant number so-and-so. Tajul Islam, son of Tahirun Nessa, sold 1 bigha 4 kata, 1 lecha, including the suit land to Srimati Rekha Rani Sen by registered sale deed number so-and-so, dated 27/10/1984. Now, this is the problematic sale deed. This is the exhibit sale deed. That from the original owner, one Srimati Rekha Rani Sen purchased. The Lordship will kindly see 1 bigha 4 kata 1 lecha. Then it says that the said Rekha Rani Sen then sold the suit land measuring 1 kata 5 lecha. Now from 1 bigha 4 kata 1 lecha, she sells 1 kata 5 lecha to Sri Gauranga Chakladhar by its sale deed number so-and-so dated 8/9/1990. Plaintiff thereafter purchased the suit land measuring 1 kata 5 lecha from said Gauranga Chakladhar by registered sale deed number so-and-so dated 20 May 1999. Well, I will not take your lordship from here further. Lordship will kindly see from the last page, the number of page 78. Page 78, lordship. Exhibit plaintiff's documents, lordship is seen, my lord. Plaintiff's documents. Exhibit 1 is the photocopy of certified copy of sale deed number 310099. That is the last sale deed by which the plaintiff was purchased. Then serial number 5, exhibit 5, photocopy of certified copy of sale deed number so-and-so of 1984 in favor of Srimati Rekha Rani Sen. And then serial number 6, exhibit 6, photocopy of certified copy of sale deed in favor of Gauranga Chakladhar. So these are the 3 sale deeds he has relied. First one from the original owner by exhibit 5 that Srimati Rekha Rani Sen purchases 1 bigha 4 kata 1 lecha. And from her, this Gauranga Chakradhar by exhibit 6 purchases 1 kata 5 lecha. From there, plaintiff purchases by exhibit 1 1 kata 5 lecha. Now your lordship will kindly see what is the finding of the learned trial court. Page 72, my lord.
Yes.
Para 18, my lord.
Yes.
During final hearing, learned counsel for the defendant number 1 and 2 disputed sale deed of plaintiff, arguing that no 4 boundaries were mentioned in registered sale deed number so-and-so dated 27/10/1984 of Rekharani Sen, the vendor of plaintiff's vendor Gauranga Chakradar. Though it appears, now this is the finding of the court, my lord, though it appears that there is no mention of 4 side boundaries in sale deed number 10306, but it appears that the land measuring 1 biga 4 kata 1 lecha was sold out of said dag and patta, that is dag number 48 and 29 of village so-and-so, Moja Beltala. Moreover, while Rekharani Sen sold the suit land, that is land measuring 1 kata 5 lecha, to Gaurango Chakladar, 4 sides boundaries were specifically mentioned. And I pause for a moment here. If the original vendor purchased, and she purchased, I show mine from the appellate court judgment, she purchased from 98 bighas of land. The Dagpatta from which she has purchased contained 98 bighas. From there, she has purchased 1 bigha something which did not have any boundary. Now, from where, from whom, which one is her land, she herself doesn't know. Now, from her land, she sells 1 kata 5 lecha to plaintiff's vendors, to a plaintiff's vendor, and from there, plaintiff vendor sells it to plaintiff. Now, Lordship, you kindly see the judgment of the first appellate court. That finding on issue number 5, my lord, starts from page 104. There, down below, Lordship has seen issue number 5 and 6. Discussion starts. Now, Lordship may kindly turn to page 107.
Yes.
My lord, after a few lines from top, maybe 6-7 lines from top, PW1, Lordship has got, my lord. PW1 also proved the sale deed number 310099, by which he purchased the suit land from Gaurango Chakradar by Exhibit 1, which I have shown. And in his evidence, PW1 also described the suit land with specific boundaries as mentioned in the plaint. Now, PW4 in his cross-examination, although deposed that there was no boundary in the land which was sold by Rekharani Sen, he categorically deposed that the suit dag was a big dag consisting of 189 bighas of land, out of which he purchased 1 kata 5 lecha. He categorically deposed that the suit land was identified by Rekharani Sen, and accordingly he purchased the suit land. Now, Rekharani Sen purchased some land from 189 bighas without any boundary. How can she say which one is her land? From out of 189 bighas, she purchased 1 bigha something, which I have shown from the trial court judgment. Based on this, my lord, ignoring this fact, the trial court says that plaintiff has a decree, title over the suit land. I have purchased 1 kata 10 lecha, and the plaintiff has purchased 1 kata 5 lecha, less than me. And she, because our land, plaintiff's land is different, they have filed the suit, implementing me as defendant. Got the decree subsequently, my lord, since there was a counterclaim, due to, according to the instruction, my lord, due to the mistake on the part of the counsel, appeal was preferred against the counterclaim, but appeal against the suit, decree passed in the suit where the decree for recovery possession was there, was filed after 1 year. In the meantime, the decree was executed, I was dispossessed. Now, since I had possession over 1 kata 10 lecha, my lord, the plaintiff dispossessed me totally by executing the decree. 1 kata 5 lecha they have occupied, remaining 5 lecha they have given to a mandir. And mandir is now there, they are also there. So this is the position. Well, I have framed the substantial question of law, my lord, in this way. Lords will kindly see page 6 of my memo of appeal. Page 6, my lord. Whether the finding of the learned courts below on issue number 5, declaring plaintiff's title over the suit land is perverse because Exhibit 5 based on which the plaintiff claim title had no boundary description as admitted by PW4 and PW6 in their cross-examination. Well, my submission is, my lord, if your lordship has that the plaintiff's vendor purchased 1 biga something from a land which is 189 bigas, and she purchased without any boundary. Which can the land which was ultimately sold to the plaintiff be identifiable, my lord? From 189 bigas, she sells 1 kata 5 letter to plaintiff's vendor with specific boundary. But you do not have your own land identified. Then you suddenly say that this is your land, 1 kata 5 letter. He sells it to plaintiff. Based on that, that is why, my lord, the schedule mentioned in the plaint and the schedule mentioned in my written counterclaim is different, because I have proved my sale deeds. My sale deeds were not at all discussed. Lordship will kindly say how the trial court has dealt with my sale deeds. My lord, page 64, I am showing what was the issue about my sale deeds, my lord. Page 64, additional issue was framed in my counterclaim. First one is whether the counterclaim is maintainable in the present form. Second one is whether the sale deed number so dated 7789, sale deed number so dated 9/4/2003, sale deed number so dated 20th of September 2006 are void, illegal, and forged. Now the finding of the court, Lord will find it page 75. Additional issue number 2. The sale deeds number so have no nexus with the suit land of the plaintiff, but the same cannot be said to be void and illegal, etc. So my sale deeds are not said to be void and illegal, but at the same time, they have got no nexus with the plaintiff, because naturally, my land I have purchased from the vendor with a registered sale deed. They have purchased from a vendor who did not have his own boundary. Naturally, it will not tally. And based on that decree, I have been dispossessed. Unfortunately, mainly because of the fault on the part of the lawyer counsel, the client says to my learned junior that he entrusted the lawyer to file appeal in both the decree passed in the counterclaim as well as the suit, my lord. Decree passed in the countering was challenged in the first appeal in 2018, and the decree against in the suit was challenged in the appeal. After 1 year, in the meantime, decree was executed. I have been dispossessed. So at this stage, I cannot pray for any stay because decree has already been executed. I am only praying that the appeal may be admitted on the two substantive question of law. First one is about perversity of finding on issue number 5. And second one is, my lord, admittedly, the plaintiff has executed all the photocopy of the certified copy. This is admittedly my secondary evidence. Now, for admitting, proving a document.
So this first one will cover the second one also, because
will
we
cover,
are
but
examining the perversity.
To some extent, it will cover, my lord, but so far as the admissibility of exhibit 5 and 6 are concerned, my lord, as your lordship has seen from the trial court judgment, this is not the original, not the certified copy, photocopy of the certified copy of the sale deed. This is not admissible in evidence. Trial court did not go into that question. Trial court says, my lord, the plaintiff has called for the original volume book from the office of the sub-registrar. But if from the office of the sub-registrar the volume book is called, then the certified, sale deed mentioned in the volume has to be exhibited, not the sale deed. Sale deed continues to be an inadmissible document, being a photocopy of the certified copy, being a secondary evidence. If the original volume book is called and the contents of the original volume book is marked as exhibit, then matter will be different. Trial court says they have brought the original volume book, it is compared, so I am proving the original a photocopy of the certified copy. That is not the law, my lord.
Okay. Heard Mr. D. Mozumdar, learned senior counsel, assisted by Mr. D. Mozumdar, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 24/9/2024. First by the learned district judge Kamrup M. entitled appeal number 25 of 2018 and entitled appeal number 11 of 2019. Thereby and thereby affirm the judgment and decree dated 38/7/2018, passed by the learned civil judge number 3, Kamrup M in PS number, title suit number 208 of 2007. It is to be noted here that by impugned judgment and decree dated so the learned trial court, the learned civil judge number 3, Wittenberg trial court, has decreed the suit filed by the plaintiff and dismissed the counterclaim filed by the appellant herein. There is the memo of appeal, the grounds mentioned therein, and also the suggested substantial question of law. And also there is the impugned judgment and decree dated 24/9/2024, passed by the learned district judge Kamrup M in title appeal number 25 of 2018 and title appeal number 11 of 2019, and also there is the judgment and decree dated 38/7/2018, passed by the learned trial court in TS number 208 of 2007. This second appeal is admitted on the following substantial question of law. Number one, whether finding of the learned courts below on issue number 5, declaring the plaintiff's title over the suitland is perverse, as because Exhibit 5, based on which the plaintiff claim title and no boundary description as admitted by PW 4 and 6 in their cross-examination. Number two, whether the learned courts below committed an error in relying upon Exhibit 5 and 6, which are admittedly photocopies of the certified copy, and therefore inadmissible in evidence for non-compliance of the provision of Rule 4 and 5 of Order 13 of the Code of Civil Procedure. Issue notice to the respondent, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the records from the learned trial court as well as appellate court. Place the matter after 4 weeks.
So there is an IA. I've got a short prayer, Lordship. May kindly take up the IA. This IA I have filed not for stay because it is already executed. I am dispossessed. I have filed this IA under Order 39, Rule 1 and 2. Lordship will kindly see paragraph 4, my lord, where I have said that what is the present position. Paragraph 4, my lord. That the applicant states that during the pendency of the aforesaid appeals, that is the first appeal, my lord, the opposite party filed an execution case being so and so for execution of the judgment and decree as so and so. The learned executive court below, after hearing the parties by order it is so and so, executed the decree and delivered possession of the suit land to the opposite party. Then para 6, my lord, that it is to be stated herein that after receiving possession of the suit land, the opposite party constructed boundary wall around the suit land, thereby enclosing the entire suit land. Later on, opposite party illegally handed over possession of land measuring 5 lectures out of the suit land to Shankarnagar Unnayan Samiti. Thereafter, the said Samiti illegally constructed a 2-storied RCC building thereon, and the ground floor thereof is used as Kali Mandir and the first floor is used as a Sai Baba Mandir. So this is the position matter. In this circumstance, I am praying for an injunction that there should be restraint for making any construction.
Already constructed.
Mandir has been constructed, but so far as the 1 kata 5 lecha land, because he said it is 1 kata 5 lecha, so additional 5 lecha he did not retain, he gave it to Mandir. I have been dispossessed, and then he gave it to Mandir. All right, my lord, I am not saying Mandir should be, but Lordship may direct that in the suit land they should not make any construction. And admittedly, they do not have any right over this land. Trial court has seen my land is different, their land is different. Our sale is for 1 kata 10 lecture. They have got a decree for 1 kata 5 lecture, disposes me from the entire land. I am out of the land. And Lordship may kindly have a look at this order, my lord, how the trial, after execution of the decree, a short or the last paragraph, Lordship will kindly see. Last paragraph, Lordship will see. So possibly this order was passed by the first appellate court since it is already executed, but don't make any construction. So that kind of order, I'm praying that before this on the court also.
No, this order relates to the present appeal. No.
No, it is before the first appellate court. When the first appellate court observed that decree was executed, because my appeal against the decree passed in the suit, where the decree for recovery of possession was there, it was filed later. In the meantime, decree was executed. So the first appellate court observed that you do not make any construction over there.
Okay, we'll see.
Or Lordship may at this stage may say, my lord, status quo, so that otherwise they will not, for years together, it will remain pending. They will raise, they have not raised any construction, my lord.
Okay, we'll see.
Then Lordship may issue notice at least on that.
No, after going through the entire
My
report,
lord,
I will pass.
some order your Lordship will pass. Your
Okay,
Lordship
we'll
has seen the nature of the order.
Item 19.
May I please, Your Lordship? Your Lordship, kindly the matter may be passed over for the day.
For the day,
Yes, Lordship.
is your good name?
B. Hajarika,
Learned counsel appearing on behalf of
R. Chaudhary.
R. Chaudhary. Price for pass over the matter for the day. Passing over the matter for the day. Accordingly, the matter stands pass over for the day.
Your Lordship, can it be fixed on 28th of this month? Wednesday,
26.
28.
Go to the registry, they will fix that.
Yes.
Item 20.
May I please, Lord? Well, this second appeal refers again the concurrent finding of the court, my lord. Second appeal order is, my lord, page 63, my lord. What happened, my lord? Plaintiff, my lord, he claimed that, my lord, he purchased the land from land by executing CASA deed, my lord. Unregistered deed, my lord. In that 1970, my lord. Thereafter, my lord, he allowed the plaintiff defendant to stay in the suit land, my lord. And he left from the suit land and he went to Arunachal land. He is heading in the Pasighat, my lord. In the meantime, my lord, what happened? Plaintiff, defendant, my lord, they obtained electricity
What is
connection.
the value of the land?
Value of the land, my lord. They purchased final payment is, my lord, it is, my lord, rupees. Value of the land is, as per, my lord, 1 lakh, my lord. More than, my lord, as per, my lord, as per property act, my lord, 54, my lord. And as well as, my lord, registration act, my lord, is more than that, my lord. Until now, if, my lord, from the, my lord, claim, my lord, case, my lord, 8. Although they said then, my lord, father of the plaintiff, along with the wife and son of Gobind Sarkar, Gopal Sarkar, and Govinda Sarkar, went to Kabi Anglong, my lord, in 1972. Although, my lord, from my WS, I am said that I have defendant number 1. He was born only on 1977, my lord. That statement is also, my lord, absolutely, my lord, incorrect, my lord. And on the other hand, my lord, plaintiff says that his father expired on 1975, my lord. In fact, my lord, from the documents, my lord, which defendant had exhibited, my lord, from that documents, it can be presumed that, my lord, 37, my lord. He made a statement before the, my lord. Before, my lord, election, my lord, officer, my lord, where he said that, my lord, that statement is the next page, my lord, 38, my lord. Record of that statement is 21/8/77, my lord. Although, my lord, he said that, my lord, his father expired in 75, my lord. Where, my lord, he said that he passes the land in 1970, whereas, my lord, in the statement before, a statement of the father or the plaintiff before the
No,
election officer, my lord.
This second appeal cannot be admitted on the question of fact
Yes, my lord.
because there is already concurrent finding of both the courts below.
Yes, my lord.
So you tell me what law points are involved here in this appeal?
Yes, lord. Let me go to the, my lord, page. Issue number, my lord. Page 77, my lord. Issue number 2 and 3, my lord. The plaintiff has filed the instead suit claiming the right title to the interest in respect of land on the basis of Kasa Din, my lord. That was executed between the plaintiff and one Nogen Bodolwe, by which the suit land, which was in possession of the plaintiff since 1970, my lord, was handed over to the plaintiff, and that the plaintiff had converted the suit land, which was closely land, to a annual quota land, my lord. In fact, my lord, thereafter he was never in possession of the suit land, my lord. On the other hand, my lord, while, my lord, obtaining the annual patta, at that time also he was not in possession, my lord. In that case, my lord, as per, my lord, land revenue regulation, my lord, while, my lord, issuing annual patta, my lord, he has to be in possession, my lord. Land revenue regulation, my lord.
You show me the written statement.
Yes, my lord. It is page 16, from page 16, my lord. Page 17, my lord. Parathi, my lord. Parathi, last portion, my lord. That the defendant number of Bektu state that as regard the Pegamnum plaintiff has no knowledge except the information that during the year 1972 he was not in bone, my lord. And and whether his father was in Kabi Anglog or not, and whether the plaintiff was doing Hazira in Shilapota or not, and because the defendant was born only on 22/10/1977, my lord. That is one thing, my lord. On the other hand, my lord, para 4, my lord. With regard to first part of the defendant completely denies that because the father was alive during 97, which I have earlier shown in the, my lord, statement before the election officer, my lord. Thereafter, my lord, there is the factual part, my lord.
On the other hand, my lord, we have also, my lord, claiming adverse possession because we are in possession for more than 20 years, my lord. And that aspect has not been, my lord, dealt by
Where
the
you have pleaded it in your WS?
WS in my lord, PA paragraph, page my lord 21, paragraph 9, my lord. From the middle portion of that. Moreover, the plaintiff had left away from the house of the suit land more than 20 years ago, and as such, he was not in possession of the suit land. And mutation of the suit land in the plaintiff name is also illegal, for which the owner may be take necessary action according to the law against the impugn husband and order granting periodic quota to the plaintiff without possession in wholly illegal and liable to be cancelled, my lord. In fact, my lord, regarding adverse possession, my lord, trial court, my lord, did not consider that aspect, my lord.
No, whether you have specifically pleaded in your written statement that you are claiming adverse possession?
Yes, my lord.
Where? Paragraph number 9.
Paragraph number 9, my lord.
In which line?
From middle portion, my lord, from 5 line, my lord. Plaintiff had left away from the house of the suit land more than 20 years ago. And since then, my lord, we are in possession, my lord.
Whether any issue was framed on this point?
Yes, my lord.
Whether any issue was framed on this point by the trial
No
court?
issue was framed by the trial court, my lord. Although, my lord, appellate court, my lord, dealt with that aspect, my lord. But, my lord, as per appellate court, my lord, I have fulfilled all aspect of the adverse possession, my lord. That is why, my lord, that was not allowed in my paper, my lord.
Okay, heard, Mr.
M. Setia, my lord.
Pardon?
M. Setia, my lord.
M. Setia.
Yes.
Learned counsel for the appellant. This appeal under section 100, read with order 41 and 42 of the Code of Civil Procedure is directed against the judgment and decree dated 25/11/2024 passed by the learned civil judge senior division Damaji in title appeal number 10 of 2024. It is to be noted here that by impugned judgment and decree dated so and so, the learned civil judge senior division has dismissed the appeal filed by the appellant stroke defendant challenging the judgment and decree dated 22/11/2018 passed by the learned Munship number 1 Damaji in title suit number 5 of 2016. Where is the memo of appeal and the grounds mentioned therein? No, it is also to be mentioned here that by impugned judgment and decree dated 22/11/2024, the learned trial court has dismissed, no, has allowed the, has decreed the suit of the plaintiff, declaring right title and interest of the plaintiff over the supplant. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the in judgment and decree 25/11/2024 passed by the learned civil judge senior division Damaji in title appeal number 10 of 2024, and also the judgment and decree dated 22/11/2018 passed by the learned Munship Damaji in TS number 5 of 2016. The second appeal is admitted on the following question of law.
Yes,
Following substantial question of law. whether on the basis of an unregistered sale deed, right title and interest over a over a land can be declared. Can be declared. And whether number two, whether without there being any physical possession of the suit land, the same can be mutated in the name of the plaintiff. Then number three, whether the impugned judgment and decree of the learned courts below suffers from perversity on account of non-consideration of plea of adverse position in its proper perspective. Admit, issue notice to the respondents returnable in 4 weeks that be taken by registered posts with AD and also by the process. Rest shall call for the record from the learned trial court as well as from the first appellate court. Place the matter of the 4 weeks.
21.
Yes, madam, there is a miscase, madam. During the sentence of the appeal, madam, I still was granted, madam. I have annexed in my,
Let notice go ahead.
yes, madam. Because, madam, already they have executed the execution proceeding, madam. Initiated the execution proceeding, madam.
What is the number of the execution case?
Madam, that number I don't have, madam. I have informed, madam. But during the whole matter proceeding in the appeal, madam, I still was granted, madam. I have annexed
If
the,
you have you received any notice from the court?
yes, madam.
When?
1 month during, madam.
Show me the
last
copy.
month.
Whether that notice is part of the record?
No, madam, that is not part of the record, but I have annexed the order, madam, whereby trial court or appellate court, madam, is the earlier trial court order, madam. 93, madam, case number. In this case, madam. During the display,
You produce the record, we will see. Heard Mr. Pegu, learn it. No, heard Mr. Setia, learn it from for the applicant. Its application under order 41, rule 5. And order 42 of the Code of Civil Procedure is preferred by the applicant for staying the judgment and decree dated 25/11/2024 passed by the learned civil judge senior division Dhemadi entitled appeal number 10 of 2024. Whereby the learned appellate court has dismissed the appeal filed by the appellant instructive contents challenging the judgment and decree dated 22/11/2018 passed by the learned Munsi 1 Dhemadi in DS number 5 of 2016. Peruse the petition and the documents placed on record. Issue notice. Interim care will be considered on appearance of the other side next day.
okay.
21.
May I please, your lordship?
Yes, Mr. Hawk.
My lord, the appellant before your lordship, he was defendant. He was defendant. Plaintiff suit was allowed and in appeal, it was affirmed. Plaintiff, defendants filed counterclaim. His counterclaim was also dismissed. Plaintiff
Counterclaim was dismissed.
Mine. The plaintiff suit was for declaration of right title and recovery of possession. My lord, the defendant's counterclaim case was that, my lord, this out of that suit land, it is 2 biga 4 katha. 2 biga has been purchased by the defendant counterclaimant, that is present appellant, by an unregistered sale deed in the year 1995. Because, my lord, at that point of time, it was, my lord, annual patta land. But it was not considered because it was not registered. Because of that, my counterclaim was rejected. Your lordship, kindly see the one of findings of the learned appellate for page 51 for a moment. Paragraph 13. Whether I will get the protection under section 49 of the Registration Act or not. That is the issue in this case.
Page number
51. Here it is also observed that it is a settled position of law that cuts a sale deed when the nature of agreement to sell can be used for collateral purpose under section 49 of the Registration Act and in a suit for a specific performance contract. When such documents are used for collateral purpose, a decree can be granted. The law has been, my lord, here my lord discussed, but my counterclaim has been dismissed and appeal has already been dismissed. 49 of the Registration Act also provides that it can be used for collateral purpose, and my lord, we have in written statement we have stated that this is a specific performance of contract we have claimed, but no issue has been in the suit file. So, my lord, page 5 we have framed substantive question of law. Your lordship kindly see for a moment.
issue number
Page 5. Substantive question of law I have framed. That is a whether the unregistered sale deed with the exhibit code, that is my links in this, tendered by the defendant in a trial is admissible as a proof of oral agreement of sale under proviso to section 49 of the Indian Registration Act. Your lordship kindly see the section 49. Proviso. Provided, my lord, 49 provided. Provided that unregistered document affecting immovable property and required by this Act or the Transfer of Property Act to be registered, it is correct, may be received as a evidence of a contract in a suit for specific performance of contract. We raised this issue, but no issue has been framed and is dismissed on this point. And second, and our Supreme Court judgment is there and can be used as collateral purpose. Supreme Court also has said collateral purpose extended.
So make the decision.
Mild. Your lordship, can we see the head in head note also it reflects in last line, before last line.
Paragraph number?
Well, first, well, this in head note, your lordship can see.
No.
Footnote.
Not head note. Which paragraph?
Paragraph
number 15.
Paragraph 10 also.
10.
10. And 15 also.
So the suit was for specific.
For contract, but that was no issue was framed, my lord, in this case. I specifically pleaded in the written statement. And in appeal also, my lord, I have raised this issue that it may be
Where
remanded.
is the plaint?
What kind is the recent statement of our? Plaintiff page 56 and written statement page 70 you have raised that.
Page 70.
In prayer portion page 73, that is paragraph 11D. Page 73. 11D, decree for specific performance of contract.
So the trial court has not relied upon the unregistered deed,
Unregistered,
not relied upon.
not really.
And as per this decision of the Supreme Court,
It
has
can
to-
be used as a collateral purpose for a specific performance contract. Even we raise this issue there in the written statement. Okay, fine.
We'll pass the order. But whether framing of all the three.
Fine.
Whether framing of all the three is
No,
suggested
possibly one is
questions
sufficient
are
because-
necessary.
No, one is sufficient, more.
One is sufficient.
My lord.
First one.
First one is,
First
second was, my lord, was they have claimed their title on the basis of Javamandi, the plaintiff. Whether that on the basis of Javamandi, he can claim his title. It is one already settled law. That I have framed second question. We have, on the basis of Javamandi, they have claimed plaintiff.
Second is also required.
My lord, your lordship. 1 and 2, two already, my lord. Have. A and G. Basically, one is for me, my lord.
No, Mr. Hawk, it is well settled that on the basis of Jamabanti, one cannot claim that.
Claim title. That is
So that is well settled.
well settled. That
So
is
how that
plaintiff claim.
question-
There is plaintiff claim. On the basis of only Javamandi. There is IA also, but your losses can look into this matter because
This would go.
executive will decree, my lord. Of course,
We'll see.
my oblige.
Spoken to items.
So Goswami, we have listed this matter today for furnishing that reply by Mr.
Lordship, I have also received copy of the
You have
written argument
received-
submitted by the learned counsel for
You want to
complaint.
submit anything?
Lordship, kindly see only one thing, Lordship, I point out. Written argument has been given, para 2, Lordship.
Which judgment?
No, written argument, they have submitted written argument.
Okay.
In written argument, Lordship will, in para number 2, Lordship kindly see, petitioners claim to be appointed as a stipendary teacher in 1995 by the Deputy Inspector of School Nazira, although claim of the petitioner if they were appointed against 610 number of posts created under OBB scheme. However, petitioner failed to substantiate their claim annexing a document in support of the genuineness of their appointment. In fact, petitioner was appointed without selection. Lordship, we have already annexed the document, selection and appointment, the Lordship 216, the list, and our respective name in the list also we have annexed.
Page number?
Page number 6216. First list is 198, page 195, 198. We have annexed the list. And Lordship has already recorded where our name has been reflected. Page 198 for Nazira subdivision.
Yes.
That is the list, Lordship. But now they have said that we have not annexed the list. And Lordship has noted it down, the number, our position in the list. Earlier, we have pointed out the number of in our position in the list. And that has been subsequently upgraded by the Director of Education, page 216. This is the Lordship in pursuant to government letter number Iman, sanction temporary retention of para number hereby accorded for the period of 2009 to 10. This has been accorded by creation has been accorded by the government, by the Director of Secondary Education. It has been communicated the office order. We have annexed the list, and list is at page 223. In respect of Nazirat Sub-Division. Secondly, Lordship, already this case is covered by judgment of this Honorable Court. Lordship is aware that his Lordship, Honorable Justice Borua has passed his judgment regarding Lordship stipended teacher 6403 of 2021. And there is another judgment of Lordship also 6403 of 2021.
So whether those two judgments are part of the record,
Lordship,
whether those two judgments are part of the record.
we have given a copy of the judgment, Lordship, para 118. Again, another page giving Lordship. Para 118. Have underlined Lordship. Stipended teacher. Another judgment Lordship has passed, Lordship, in case of BTC area. That is also Lordship, I have given the number. So this is my reply to the written argument. Okay. So they have annexed some judgment, but basically this case is covered.
Lordship, my 2-point clarification, Lordship. In so far as without selection process, meaning thereby, there were no advertisement, no any selection process were followed. That is my point. In so far as the
No,
without
they
any
have
selection
undergone,
process-
though they were, at first they were appointed as stipended teacher,
Lordship.
their service were regularized after.
No, that is why I have annexed some judgment, Lordship, because the very entry into service is illegal. Therefore,
How it is illegal?
without following any due process of law, Lordship.
But then how
activity is also there.
how the respondent authorities regularize their service?
Lordship, initially they were appointed by the DIF school without any sanction post. And subsequently, Lordship, when that is why I have clarified in my written submission as well as in the affidavit also. Lordship, kindly peruse my written submission where I have stated my submission, page number 10 of the written submission. That the petitioners were illegally appointed by the then Deputy Inspector of School without selection process against non-existent posts, reverse the Rule 3 of the Assam Elementary Education Provincialization Rule 1977 provides the method of recruitment, which provides for a public participatory selection process by issuance of advertisement. The selections list so prepared by the second selection board under Rule 3(1)(b). After completion of the interview of the shortlisted candidates was required to be authenticated by the director before publication of the same. However, in the instant case, no such selection was held as per Rule 3 of the Rules of 1977. Admittedly, Lordship, page number 11. Appointment of the petitioner in the instant case were made without any sanction post, without any advertisement, giving opportunity to all eligible candidates to apply and seek public employment, and without any method of recruitment. Be it be stated herein that the appointments without following procedures prescribed under the rules and without advertisement amounts to breach of Article 14 and 16. Lordship, I have placed some judgment, Lordship, here of the Constitution of India. It is more res integra that the right, it is no more res integra that the right to salary, pension, and other services benefits are entirely statutory in nature and in public service, and therefore the rights, including the right of salary, spring from the valid and legal appointments to the post. Since the very appointment of the petitioners are illegal and non-honest in the eye of law, therefore, petitioners are not entitled for salary as provided for in the writ petition. Hence, the writ petition is devoid of merit and liable to be dismissed. The appointments is paragraph 16. The appointments found to have been made in violation of the statutory provisions, procedural requirements, or based on the false information are considered void ab initio. Because the very appointment is void ab initio, meaning thereby they are null from the outset and have no legal existence and effect. That since the entry into service of the petitioners is per se illegal and hence void ab initio appointment do not confer any legal right or status. All action based on such appointments, it is more important, Lordship, it is all action based on such appointments, including payment of salary, continuation of service, or conferment of benefits, are also invalid from the outset. And the Honorable Court have considered that I have already placed the judgment. The Honorable Courts have consistently held that consequential action taken pursuant to the void ab initio appointments are themselves invalid and cannot be validated retrospectively. The doctrine of void ab initio applies strictly to appointments made contrary to law, statutory rules, constitutional provisions, not merely irregular or procedural lapses. Therefore, this is my submission, and there's no Lordship. Some judgments are there, Lordship, in support of my submission, Lordship.
Page 134 of the writ petition, division bench of this honorable court pass a order in favor of the petitioner. We have annexed in the writ petition, page 134. Lordship.
Yes.
Mahendranath Mohanto, Lordship, got it. Mahendranath Mohanto, present petitioner, and others. Now, Lordship will page 139. Relevant portion. That is a division bench order. Taking into consideration, Lordship got it. Taking into consideration the totality of the circumstances, it is hereby directed that arrear and dues with effect from 1/12/2009 to 31st April 2010 shall be paid by the government to the concerned and all other teachers within 1 month from today, and government and the officers shall ensure payment of monthly salary to the teacher latest by the 15th of each succeeding month. Respondent number 2 to 7 are hereby forwarded that if this direction is violated by them, they would be exposing themselves to serious consequences, including contempt proceeding. This is division order. Against that order, they have filed SLP or they have set aside this order.
Moreover, there is another writ petition pending, Lordship. Yeah, filed by the writ petition number 1 and 2 that I have already stated in my submission, pending disposal, and followed by some 2 contempt cases are there.
This is regarding pension. Because some of the 3 petitioners is retired from service, this court has directed to give pension following the judgment of this honorable court, and they have not paid their salary till today, pension.
With that effect, that the speaking order has been passed, that is part of the related submission, Lordship.
Any other points? No. Heard learned advocates of both the parties. Order reserved.
For bail hearing, pending items 43 to 46.
But here I have obtained the judgment. With regard to Article 22(1).
Paragraph number?
Paragraph number, my lord, 20, 21, 22, 23.
Yes.
Paragraph 34 also, my lord, it says the clause 2 of article, clause 1 of article 22, it came into play as soon as person is arrested. So, my lord, my thing is that I was arrested before the Pankaj Bansal case judgment. So, I will not be affected by the Pankaj Bansal decision of the Pankaj Bansal case because it is constitutional provision.
You were arrested after?
Before
Before.
before the judgment of is raised objection by my planet. I was arrested on 1/9/23. So the constitution itself says, Article 22(1) says, my lord, that right, my lord, comes into play, my lord, as soon as the person is arrested. So it is always there. It cannot be said that it comes into play after the judgment of Pankaj Bansal. So from the very initiation, my lord, of the constitution.
There is no doubt about it.
And my lord, I have also
Question is,
some,
the observation made by Supreme Court in the case of Ram Kishore or
but it is
regarding
prior
the
to,
retrospective effect.
but I have some another judgment also that is of our High Court given on 5/5/2025. Here also after detailed discussion, bail was granted. Lord, referring to some other judgment regarding the, here says, my lord, all our judgments are with effect, are effective from retrospective, are retrospective effect, my lord. Yeah, my lord, that is paragraph 18.
Okay. Yes, Mr. Bortakor.
Otherwise, regarding this point, I have already argued regarding 22(1) and effect of Pankaj Bansal.
The other day, one judgment was referred of Karnataka High Court. Have you gone through the same?
Yes, otherwise, please are attended. My lord, regarding that, my lord, he is trying to point out at that point of time, Mr. Das was there, my lord. He is trying to point out that in case of, my lord, PMLA, my lord, that provision was applicable only in case of, my lord, PMLA. That because Bansal government was only in case of PMLA, but not in case of, my lord, IPC. But my lord, regarding that argument, I would like to point out before your lordship, on the one hand, their argument is that violation of Article 22(1), and now, my lord, they are trying to make an argument because Pankaj Bansal goes against them, my lord. They are trying to, my lord, make an argument that that is applicable only in case of PML. Then what about, my lord, Article 21? What argument they have, my lord, since earlier, my lord, their argument is Article 22(1) violated, my lord. They are by their argument itself, my lord, they are trying to create difference between, my lord, PML offenses and my lord, and the provision of Article 22(1). So, my lord, that argument, my lord, there is no substance in that argument, my lord. And otherwise, my lord, my argument, my lord, I speak to my argument that Pankaj Bansal judgment was passed on 3/10/23. And my lord, Pankaj Bansal itself, by using word henceforth, said their judgment is prospective, and thereafter, my lord, was strengthened by Ram Kishore was so, my lord, there is nothing to, my lord, argue on that point. That point has already been, my lord, while Ram Kishore, my lord, more strengthened, and I have also pointed out two of the coordinate cases judgment of this honorable court, my lord, in his regard.
But my lord, I have submitted the judgments where my submissions of my friend that had been submitted before the honorable court, that has been not accepted, my lord. Even I am giving another judgment which says that, my lord, until and unless it is mentioned, specifically mentioned in the judgment, it is to be affected prospectively. It cannot be prospective. I am submitting this also, my lord. The Supreme Court judgment, but honorable Supreme. Now it is clear, my lord. Yeah. I am reading it out. The Honorable Supreme Court clarified that, my lord, in Kanish Sinha, my lord, that is My lord, page 3. Page 3, my lord, from the middle. The appellant number 1, all the same who argued in person before the High Court, emphasized before this court and would argue that all the judgments of these courts are retrospective in nature, and therefore it cannot be said that this would be not be retrospective, particularly when it has not been specifically stated in the judgment of so and so. It will operate prospectively. Now, my lord, next page. Now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature, unless it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law, which is laid down by a constitutional court or law, as it is interpreted by the court. The judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. So, my lord, in terms of this, my lord, our High Court considered again another bail application, which I have given to my lord. That is bail number, BA numbers 3043. Muhammad Noor Muhammad. After discussing everything, bail was granted. Bail number 3043, my lord. Just I have given to my lord. And in paragraph 18, 29, 30, 33. About this retrospective and prospective effect, that has been taken care of, but has not been accepted by the Honorable Court. I have also, my lord, another judgment. Here, my lord, again, accused was arrested on 9/8/23. Again, our High Court again granted bail. As we are discussing all of the judgments referred by my learned friend, I am also placing another judgment of our High Court regarding section 50 of CRPC. Here says that if there is violation, this is also 1976. 1976, my lord. It also says if there is violation of section 15, arrest is assailable. Paragraph number, my lord. Ajit Kumar Sharma, my lord, in paragraph number 5 and 6. So my submission is there, my lord. We are on our right granted by the Constitution is violated. So it flows from the very 1950, my lord, when Constitution came into force, my lord. This right cannot be.
Mr. Khondokar, learned counsel for the petitioner, and Mr. Bhattakur, learned.
I would just like to add one more point, my lord. Your lordship may kindly peruse, my lord, there is one additional ground, my lord. Page 33, my lord, of this petition, because this is NDPS, my lord. My lord, one of the my lord, recently, my lord, one courtmate page of our High Court, while distinguishing the fact of Bihan Kumar and that case, my lord, regarding grounds of arrest, my lord, I would your lordship, in this case, because this is my lord, offense under NDPS Act. Here, page 33 of the petition, my lord, I would just like to point out, my lord, notice. Page 33, of item number 43. Because in the case of Bihan Kumar, my lord, no such here you are hereby informed that you have been arrested in connection with the above reference case. The section of law of the case are not available for police, hence needed to be arrested and will be forwarded to the Honorable Court. You can move bail before the Honorable Court. So second part is, my lord, regarding Article 22(2). And first part, my lord, in that respect, I'd like to, my lord, I would like to, my lord, read
one of the paragraph of the coordinate bench of this honorable court, my lord, wherein in the cases cited by the learned counsel for the petitioners, there is a specific finding that grounds of arrest were not served on the accused persons. Whereas in the present case, although my case is slightly different because there is no column in my arrest memo, here in this case, my lord, arrest memo, and in additionally section 50 CRPC notice also, my lord, as per the NDPS set, my lord, section 50, section 50A, my lord, 50A is my lord, office to be related, everything is there in the record, my lord. Grounds of arrest were not served on the accused persons, whereas in the present case, the scanned copy of the case records on recently on 1/5/25 passed by the coordinate bench of this honorable court, paragraph 24 first one. In the cases cited by the learned counsel for the petitioner, there is a specific finding that grounds of arrest were not served on the accused persons. Whereas in the present case, the scanned copy of the case records produced disclose the very existence of notice under section 50 CRPC and a separate arrest memo, which discloses grounds of arrest wherein it is stated that sufficient evidence found against him. Therefore, merely because the not my lord, here, but my case is slightly different because that column regarding my lord, grounds of arrest, that is not there in this case. But however, section 50 notice is there and section 50A notice is also there. But in Bihan Kumar case, my lord, there is no such communication of my lord, grounds of arrest. My lord, their grounds was also taken by the petitioner, was not even informed, and no communication of the grounds of arrest. And there is no such notice. But here in this case, my lord, section 50 and 50A notice is also there. So, my lord, on that regard, my lord, and I would like to also submit before your lordship, well, above the grounds that which I have taken, that in this case, my lord, he is entitled to get benefit because of Pankaj Bansal. But here also, my lord, even Bihan Kumar also complied with, in view of my lord, in view of supplying of section 50 and section 50A. Otherwise, my lord, my first term that he is not entitled to get benefit in view of Pankaj Bansal, I stick to my argument.
My lord, since my friend is saying that section 50 and 51 comply, my lord, no ground is there, only reference. You have been arrested with so and so case number. That cannot be, my lord. It is, so it cannot be. Even section 51 also not complied. Even in forwarding report, my lord, there is no ground, only reasons, but reasons and grounds are also different, my lord. Even forwarding report.
Your lordship may kindly page 16 of this, my lord, just like paragraph 16, my lord. Coming to the cases cited by the learned counsel for the petitioners, it is observed as follows. In the case of Bihan Kumar, the learned counsel for the petitioners has referred to paragraph so and so has submitted that owing to non-compliance of the requirement of informing the arrested person the grounds of arrest, the arrest stands vitiated. However, it is seen that in para 12 here of the Supreme Court of India had referred the constituent bench decision so and so of the requirement to communicate the grounds of arrest. In para 13 of the cited case, the Supreme Court of India has also referred to the case of Lalubhai Jagibhai Patel versus Union of India, and wherein it is observed that the detainee must be communicated to the grounds of arrest. In the cited case of Bihan Kumar, the grounds of arrest was not communicated to the appellant. Well, in case of Bihan Kumar, the grounds of arrest was not even communicated to the appellant, my lord, and not their ground is also taken by my lord that Bihan Kumar, in fact, my lord, which is not similar to the facts of the case. In the there was no such notice, my lord, because that was a my lord offense under section Indian Penal Code, my lord. And here, my lord, NDPS offense under NDPS cases, section 50, section 50A notice, everything is there. And my lord, 22 2 part
my lord, second proviso that you are entitled to, my lord, apply for bail, my lord, that everything has been mentioned, my lord. Okay, we'll see. So not only because of my lord. Order is that.
Even my lord, paragraph 14.
Yes, next item.
44.
I'm deeply.
Mr. Das, it is the same argument?
Yes, my lord, I'll just simply reiterate few things, my lord.
Pardon?
I'll just like to reiterate few things, my lord. That what I yesterday, my lord, last occasion, my lord, I submitted that, my lord, here contention is that the judgment in Pankaj Bansal is prospective, for which, my lord, all the arrests where, my lord, the grounds of arrest, my lord, were not communicated prior to 4th of October 2023 will not come under the ambit of Pankaj Bansal. So regarding that, my lord, I had earlier submitted that Pankaj Bansal judgment applies squarely to cases under section 19 of the.
No, you are repeating the same
Yes,
thing.
that's what, my lord. So my lord, I
Heard
just
Mr. S. Das, learned counsel for the accused, and Mr. Portakur, learned additional PP, argument concluded, order is that.
Well, I'd like to furnish two judgments of the court that.
45.
Argument examined. Okay.
46.
Third year.
May I please, your lordship?
Yes.
In addition to earlier submission, lordship, I want to add some submission. No, if
Yes.
as per record, your lordship, the grounds of arrest has been not communicated in writing because only in the notices are reference are made. Even orally also not communicated to the petitioner, lordship. The Article 22 clause 1 of the Constitution, which states that the grounds of arrest should be informed to the person who is being arrested as early as possible, lordship. It is silent, lordship, that the grounds of arrest should be whether it should be in writing or whether it should be oral. It is not there, lordship. It is come after Bihan Kumar only, lordship. It is came to light. It is silent regarding the oral or writing. But my contention is, it is upon the investigating agency whether they will provide oral or writing. But they chosen to provide in writing because they have issued the notice under section 50 of CRPC, lordship. But in the particular notice, there is missing the ground of arrest. So my contention is that the pure clearly violation of Article 22 clause 1, lordship. And there is no material available on record, lordship, that they have stated that whether the grounds of arrest is communicated to the accused persons. There is no material, lordship. And I want to furnish, lordship, the orders of the coordinate bench.
Learned counsel for the accused, that Mr. Portakur, learned additional PP for the respondent, argument concluded, order is there.
Item number 23. Orders.
Can be taken after some time. Mr. Gupta is on legs, my lord. After some time, is on legs, my lord.
Not after some time. You Suzy that take from him.
24.
May I beg your lordship? Payment has not yet been made.
Mr. Gogoi? Okay, I got my third to stand over for the day. Stand over for the day.
The budget and financial sanction has already been received also. But FOC has not yet been received. This FOC will be done through online process. We don't have right to interfere in the online process. There are a lot of
There are a lot of FOC pending in the finance department.
No, you tell me when you will be able to complete the process, after 1 year or 2 years?
Our part has already been done, Lordship. It is on the financial department, FOC has to be released to us. So we don't have right to interfere in FOC releasing matter. As because of it will be online process.
No, you tell me how much time it will take.
It is about electronic. I have instructed that it will be an online process. It is an online process, lots of FOC, lot of FOC.
So you will not sanction it for another 10 years, then we will wait for it.
It is not.
Then
We have a required step, all the required step already has been done by us. Lord.
Mr. Solia is available there. Solia, Finance Department. So Potter says I will wait for some time and let the council for Finance Department.
Department 26.
Please, your lordship. My lord, in this case, the counter filed by the state, I received a copy today, my lord. So maybe listed on some other day.
Heard Mr. Islam, learned counsel for the petitioner, and Mr. Your name, please.
I'm for response number.
5.
Response number. 5.
Your name, please.
Name.
Yeah, within.
Jay Abedin.
Abedin.
Abedin, respondent number 5. Mr. Biswas, you are for? Respondent number? 5. Okay. And Mr. Sorma for? 1, 2, 3, and 4. You have filed the affidavit. Mr. Sorma submits that he has filed his affidavit in opposition. And Mr. Abedin submits that he has received a copy today and he may be granted some time to file reply to the
I don't need to
affidavit.
fill the reply, I can just go through my.
Okay. As for granting him some time to go through the affidavit in opposition filed by the state respondent. There is accordingly allowed to settle the matter after
Kindly-
1 week.
Kindly fix the case, my lord. Kindly fix, my lord.
I'm 6/24. Another.
5620, yes.
6/24, I have 5.
And in the other matter, 3515.
Double to 85.
Double to 8 connected. Yes.
Double to 85. Here I have not filed instruction already. Here I am repeating.
Okay. Heard Mr. Biswas, learned counsel for the petition. And Mr. Abedin, you are for?
My lord, in this case, I'm not there. my lord.
You are not there. Okay. And also heard Mr. P.N. Sharma, learned extending counsel for the respondent seat, Elementary Education Department. Elementary Education Department. Mr. Sharma submits that instructions are awaited and place for listing the matter after 1 week. 1 week. Where this shall be the matter after 1 week.
My lord, it will be on 11/6, my lord.
Which,
11/6.
my lord, there is an interim order in IA, my lord. In
Okay,
first
interim order pass out there. Shall continue.
oblige.
27.
May it please, my lord.
Well, on the last occasion, my lord, we had argued that whether the industrial tribunal is the proper forum for preferring an appeal under the POSH Act 2013. Last occasion, my lord, the respondent number 1 had supplied a copy of a notification by the governor, my lord, 2017. So my lord may pass an appropriate order, my lord, basing upon this notification. We have no objection.
So you have to prefer the appeal before this authority.
They can prefer. We have not preferred. Respondent
Okay.
number 1.
We are the appellate before the.
Okay.
tribunal.
My lord may
Now,
pass.
Forum will be lordship instead of tribunal, it will be the secretary department.
First Mr. Iqbal, learned for the petitioner, and Mr.
Lot while appearing.
Respondent number 1.
Respondent number 1.
Mr. Nayak for respondent number 1. Only one respondent.
Only one respondent. Other one was struck out.
So we will pass the order on the basis of this
My lord,
notification.
notification
Then,
2000.
relevant act. What are the acts?
POSH Act, my lord.
Industrial
Industrial-
employment.
One I have already supplied, my lord.
Yes, that
Standing
is
orders
available.
Act 1946.
Then the other two acts.
The
Lordship, 3 provisions are there. Lordship.
Bank-
One is section 8, that is the appellate provision under the POSH Act, Lordship.
Hmm.
Lordship, next one is rule 11 of the POSH rule, Lordship.
One is
One is section 18, Lordship, under the POSH Act. And second one is rule 11 under the POSH rules, Lordship.
yes.
And the third one is this notification, Lordship. These 3 will suffice, Lord.
and the other two acts that my lord was talking about.
Okay. We are closing this petition.
My-
Now the.
Granting liberty to the parties to approach appropriate forum.
As advised.
Yes, Lordship is granting us the liberty to approach
Yes.
the appropriate authority, that is the secretary, Lordship.
Deeply obliged.
Obliged.
Thank you for responding, madam. And inform that 10 days time final objection in delay convention.
Lordship, here one thing, in fact, in February also they took time for 4 weeks.
Hmm.
And since February, this has been passed. And nextly, Lordship, this is an application not under section 5 of the limitation. It is a petition under section 14 for the time spent that has been exempted by section 14, Lordship, in wrong forum. What happened, Lordship? It is an order of injunction that has been passed against me, and under misadvised, Lordship, I filed it in the Court of the Learned District Judge at Tinsukia. So District Judge in the law after exhausting 328 days, Lordship, disposed of that this court has no jurisdiction. That is what is the order before your Lordship in this IA. So under such circumstance, Lordship, what happens? The delay as calculated by the office note, Lordship, 28/6/24, the delay has been shown as 320 days. So 320 days delay is there, and on the other hand, 328 days spent there in the Court of the Learned District Judge, Tinsukia. Under such circumstance, Lordship, there is no delay at all. Question is that, however, there is a delay because the time prescribed is by the Limitation Act, 90 days to come before your Lordship. Under such circumstance, Lordship, in fact, if your Lordship assumes that there is no delay at all, so what objection they will file? If Lordship, this party is concluded, Lordship, by disposing of this appeal, my humble submission is this. If this is disposed of, Lordship, they may file their objection, if any, in the appeal itself.
I'm paying for my 1 week now. It's not fixed after 1 week. After 1 week, I'm paying for 1 week time.
What objection will you file?
I think he said the client could not come to swear it, my lord, that's fine.
Would not come to?
Swear the affidavit, he will be coming on Monday. So any day next
No,
week,
no.
lordship will
Whether your affidavit will change the position of law,
not.
then admittedly, the matter was pending before the district judge in Sukia. So under section 14(2) of the Limitation Act, he is entitled to get continuation of aforesaid period. Any dispute regarding this?
No, no.
Then he also could not obtain the certified copy in time. So 12 days has to be excluded from there. Then,
Even my formal objection may come on record, my lord, that's why I'm there.
pardon?
A formal objection may come on record. The client wants to file an objection. That is my instruction. I'm leaving to your lordship. Otherwise,
No, no. Why should we keep the matter pending? Because your affidavit will not change the position of law.
I'm leaving to your lordship. We'll pass.
If you have any objection, you may file in the appeal itself. Heard Mr. L. Talukdar, learned counsel for the and also heard Mr. Your good name, please.
RS Mr.
R.S. Mr. Learned counsel for the this application under section 14(2) of the Limitation Act 1963, read with order 41, rule 3A of the section 10, section 151 of the Code of Civil Procedure, is prepared by the applicant for exclusion of time of proceeding bona fide in court without jurisdiction, in the court without jurisdiction. Mr. Talukdar, learned counsel for the applicant, submits that the applicant hearing that preferred an appeal. Where is that order of the appellate court?
Lordship, the page 33 of the IA, Lordship. Last page, Lordship. Otherwise, it is in the first also, the certified copy.
One miscellaneous appeal being missed appeal number 30 of 2023 before the Court of Learned Additional District Judge in Sukia against the judgment, no, against the order passed by the Learned Civil Judge Senior Division Tinsukia in Mijje case number 63 of 2019 arising out of title appeal number 30 of 2020.
Miss appeal.
Mr. Talukdar further submits that after hearing the matter on 4/5/2024, the Learned Additional District Judge has passed an order that the value of the suit is being 20 lakhs. As per Bengal, Agra, and Assam Civil Code, Assam Amendment Act 2021, the state court has no jurisdiction to proceed with the matter further. And thereafter, the learned appellate court has granted liberty to the petitioner to file the appeal in appropriate forum. Mr. Talukdar further submits that as per office note, there was delay of about 412 days and 2 days spent in obtaining certificate copy and limitation was 90 days and thereafter there remains 320 days and in the court of learned additional litigious, the applicant has spent how many days?
328 days, Lordship. That has
328
been
days.
total 328 days
Total
spent in that court, Lordship.
328 days. And as such, there is no delay in preparing the appeal and the period the applicant herein had spent before the Court of Learned Additional Litigious Tinsukia has to be excluded under section 14(2) of the Limitation Act. Mr. Learned Counsel for the respondent, however, submits that he may be granted some time to file the affidavit, not to file the objection. But it appears that as per provision of section 14(2) of the Limitation Act, the applicant herein is entitled to get exclusive of the time of proceeding bona fide in the court without jurisdiction. That being so, the objection will not change the aforementioned provision. And taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this could be inclined to allow this application. The period of 328 days from 12/6/2023 to 4/5/2024, during which the applicant was prosecuting the appeal before the additional litigious number 2 Tinsukia, he excluded from the competition of the limitation period for filing the present appeal under section 14(2) of the Limitation Act 1960. In terms of above, this application stands disclosure. In view of the order passed in I number 2192 of 2024, now the registry will proceed to register the appeal and list the same before the court as soon as practical.
Copy of the appeal is served to us. Copy of the appeal memo is served to us.
Appeal number. Mr. Mishra submits that he has not been furnished with a copy of the memo of appeal. Mr. Talukdar, learned counsel for the applicant, undertakes to furnish a copy of the same to Mr. Mishra during the course of the day. Today,
I should be question.
one minute.
Item 29.
Lordship, I'm sorry, Lordship. IA is also there. Registry may be directed to register that case also for stay. Anyway, Lordship. IA,
No,
along with
once,
the appeal.
no. Once the appeal is registered, I will definitely come along with this.
29.
How like that?
My lord, in this case, I appear on behalf of respondent number 1 and 5. Since it's a partition suit, my lord, the other parties are not there necessary, my lord, because we are representing them. So I will be disposed of with him.
This I is for what
Delay,
purpose?
delay competition.
150 days.
Delay competition.
You are representing all the respondents.
1 and 5, my.
So others belongs to same family.
Same family, my lord. In fact, one is the brother of the other respondents.
Heard Mr. Ayuddin, learned counsel for the applicant, Sir Iqbal,
For 1 and 5.
counsel for the 1 and 5. Yes, Interlocutory application under section 5 of the
My lord,
Limitation
we have
Act.
objection. Yes, sir. We have objection. We have filed the objection, my lord.
What is the objection?
Objection is that, my lord, they are saying that, my lord, the appellant number one,
Document not submitted.
1, 3, 4, and 5, my lord, they are old and ailing. Whereas their age is around 55 to 60, my lord. Only one of them is, my lord, aged, my lord. No documents to prove that, my lord, they were ailing at the time when the appeal could not be filed. Respondent number, my lord, may kindly come to para 5, my lord. No documents to substantiate that claim. Para 5, the statements made in paragraph.
So far material point is concerned, my lord, they have not objected. Only objection is that not supported by any document.
Para 5, my lord, has got.
Sir, material part is concerned, there is not.
That is the material part, my lord.
Otherwise,
They have to
parties
show
are belong to same family, it is a partition suit.
They have to show sufficient proof, my lord. Judgment was passed in the month of October. They had preferred the appeal in the month of July, my lord.
So we will hear the appeal on merit.
That my lord may just kindly come to para 5.
Para?
Hardly it will take 2 minutes. Para 5. Let the statements made in paragraph number 4 of the application motivated so and so. Application have stated.
No, Mr. Iqbal, merely because he could not enclose the medical documents. Can we disbelieve his
Then
person?
there was another appellant, my lord, who was young, my lord, and they have said that, my lord, he was in of election duty, my lord.
My friend is a Friday.
Mr. Iqbal, you see, unless we admit the appeal, can we hear the matter?
No, my lord, the sufficient cause that they are trying to show, that is not there. That is what I'm trying to portray, my lord. Rest I leave it up to your lordship, my lord. But otherwise, it's a partition, so they have admitted also that, my lord, it is the ancestral property.
Okay, in which paragraph you have mentioned the cause of delay? Grounds
4,
of
my lord,
delay?
paragraph 4.
Paragraph 4.
Yes.
What is the ground?
Paragraph 4, my lord, first one, 1, 2, 3, and 5, they are old aged and ailing person, my lord. And only 4, my lord, he has to take his stay. And he is a government employee. And in the relevant point of time, my lord, he was, my lord, on election duty. So he was not granted leave. Because of non-availability of leave, my lord, he could not approach the court in time.
Since the month of October to July.
Yes, so on account of this concert election, leave was not granted to the employees.
My lord, leave that was for the year 2023, ma'am. For the year 2023, ma'am. From October 2023 till July 2024, my lord. They could not file because he was in election duty. Election was not held for, my lord, 7-8 months altogether. At that stage.
So when the election was declared?
24, sometime in March, in between March and April election had. But prior to that, being employee, my lord,
not granted leave.
My lord.
Yes, Mr. Gogoi. So since when a leave was not granted to the employees of the state government on account of this election, concert election, can you say?
কিমান দিন আগৰ পৰা DPA দিয়ে?
No, you are not a party here.
Lordship.
I just only want to know from you.
Normally, কিমান দিনৰ আগৰ পৰা ছুটি নিদিয়া নহয়?
So as per when the election, the date of the declaration of election day, when the election will have declared, till then, so far my knowledge is concerned, no state employee leave not been granted. So far my knowledge is concerned, except whenever someone has father, mother,
This is
or
not the
relative
case.
was died. It is the exceptional. It is correct.
Here in 24, my lord, no, sometime in 27th or 28th of February, election was declared.
Election has to be declared after before 2 months, I think. That's why during these 2 months, no state employee leaves have been granted.
So Iqbal will hear the matter on merit.
Merit.
Let us condone this one. So condonation of delay of 150 days in preparing connected.
First.
Regular first appeal.
Right.
Against the judgment and preliminary decree dated 9/10/2023. Passed by the Court of Learned Civil Judge Senior Division at Morio in title suit number 2 of 2017. It is to be noted here that by impugned judgment and preliminary decree dated 9/10/2023. The Learned Civil Judge Senior Division Morio decreed the suit of the plaintiff
Receipt was issued.
declaring that the plaintiffs jointly have 2/5 share in the suit land discrepancy due A to F of the plaintiff and to separate position and also issue permanent injunction and issue precept. Mr. Utin Learned Counsel for the applicant submits that the applicant could not refer the appeal within the stipulated period. That's because applicant number 1, 2, 3, and 5 are old and aged and ailing persons suffering from various age-related diseases. And the applicant number 5 is a government servant and he was on election duty for the last general election. General election or panchayat election?
General election, 24 my lord, parliamentary election.
Parliamentary election. And therefore, he was not granted leave during the entire period for which the appeal could not be prepared in time, and the same has been explained in paragraph number 4 of the application. So then submits that the delay is not intentional, rather it is circumstantial, and there is sufficient ground for hearing the appeal on merit, and Sir Putin therefore contented to allow this application. The equal, however, file objection in condoning the delay on the ground that no medical document in respect of the applicant number 1, 2,
3 and 5.
3, and 5. Are furnished by the applicant, and as such the grounds so assigned for delayed filing of the appeal is not acceptable, and therefore Mr. Iqbal has consented to dismiss this application. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record, and also the statement of environment made by the applicant in paragraph number 4 of the application. It is a fact that no medical document has been enclosed to substantiate that the applicant number 1, 2, 3, and 5 are old, aged, and ailing persons. But it appears that but it is not in dispute that the applicant number 4 is a government servant and he was on election duty in the last general election for which he was not granted leave On such ground, the appeal would not be filing time. Just taking note of the submission of learned counsel for both the parties and also considering the grounds shown in the application for delayed filing of this appeal. This court is of the view that the delay of 150 days in delayed filing of the appeal is sufficiently explained, and therefore this court is inclined to condone the delay. Accordingly, the delay of 150 days in filing the RFA, regular first appeal, stands condoned. In terms of above, this IA stands closed, and in view of the order passed in IA, the registry will proceed to register the appeal and place the same before the court as.
My lord,
Problem.
just one prayer, my lord. While listing the appeal, my lord, my name may be shown. Contents.
Okay. It is further provided that the registry shall reflect the name of Mr. Iqbal, learned counsel for the appellant, in the cause list.
Responded.
And a copy of the memo of appeal may be
Yes.
furnished.
Okay. As submitted by Mr. Iqbal, Mr. Uddin, learned counsel for the applicant, is directed furnish a copy of the memo of appeal to Mr. Iqbal during the course of the day.
Item 30.
My lordship, the application for substitution, the respondent number 1 died on, my lord, 11/1.
Respondent number 1.
1 died, Rajendra Prasad, he died.
So any objection?
Application is filed within time.
No objection. Heard Mr. Upadhyay, learned counsel for the applicant, and Mr. A. Hussain, learned counsel for the respondent opposite party. As interlocutory application under Order 22 Rule 4, with Section 151 of the Code of Civil Procedure, is preferred by the applicant for substitution of legal heirs of the deceased respondent number 1. Mr. Upadhyay submits that the deceased respondent number 1, namely Rajendra Prasad Singh, suffered demise on when?
He died on 11/1.
11/1/2025. And he left behind 4 legal heirs.
Yes.
Namely Srimati Beena Devi,
Yes.
Ramkishore Singh, Pittu Singh, and Bhanti Singh.
Bhanti Singh.
And those legal heirs are required to be impeded as respondent number 1A, 1B, 1C, and 1D in the RSA number 194 of 2019. And as such, Mr. Upadhyay contended to allow this appeal. Now allow this application. The learned counsel for the respondent opposite party submits that he has no objection in the event of allowing this interlocutory application. Having heard the submission of learned counsel for both the parties, I have carefully gone through the application and the documents present record, and taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this interlocutory application stands allowed. The 4 legal heirs of this is respondent number 1, Rajendra Prasad Singh, being pleaded in the RSA as R1, R2, R3, and R6. No, 1A, 1B, 1C, and 1D.
Yes.
In terms of above this, IA stands closed. IA stands at disposal. Mr. Upadhyay shall furnish the amended cost title within a period of 1 week from today.
Pending matter 24.
Mr. Bopuzari,
Yes, my lord.
so we want some assistance from you.
My lord.
So this matter is pending since long for FOC.
Yeah. Now, my lord, I have seen the paper, the lordship is taking up this instruction dated of 19th May.
Yes, yes.
In the second page, lordship will find, my lord, this is the financial sanction. Second page is financial sanction, and the third page, my lord, will find the budget allotment. Now, hereafter, my lord, for releasing the money, the proposal in the form of fixation of ceiling, which we normally call as FOC proposal, that has to be sent to the finance department. And perhaps that has not been sent. Now, this instruction lordship will mark it, my lord. This is from the district commissioner Kokrajhar. FOC has to be sent by the administrative department, that is the GAD, here, General Administration Department. So let them send that, my lord, FOC proposal to the finance department. Thereafter, the finance will consider, my lord, whether there is any fund or not, whether there is any infirmity in the proposal. Because as of now, I cannot say anything, comment on this, my lord. Because it is
No, that's
incomplete.
all right.
Yeah.
You obtain instruction and let this court know.
No, my lord, I cannot obtain instructions because of the simple fact, my lord, I need to have the proposal number. There is no proposal number here.
Mr. Gogo, you will help you.
So he will have to give me, my lord. If at all it is sent, and that is to be sent by the General Administration Department, not by the Office of the District Commissioner. It is in between government to government, the department. Here the department concerned is, my lord, whom my learned colleague is representing, my lord. This is for the General Administration Department. So it will have to be clearly stated that on so and so date, this is the FOC proposal, send it. And that is sent for online mode, my lord. It is electronically sent. It is a system generated, my lord. System.
So, yes, Mr. Gogo, whether it was sent to the department or not.
Lordship, we have changed the budget sanction proposal to the concerned department. And FOC has to be prepared and sent by the general.
Yes, Mr. Popon.
Yes, Lordship, on the last occasion, I had not given the thing, we get my instructions, updated instructions. Lordship will fix it the next week and get my instructions because we're not in the meantime in one of the person, the initial person has been expired. Right has.
No, the legal hairs have been impleted already.
So, my lord, I will get my instructions, my lord. What is the current status? Because as far as I know, my lord, 31 the FOC was my oral instructions. Let me get my full instructions, different instructions, and place it. If we forget to, my lord, after a week, then my lord, get the share it with my colleague.
Heard Mr. Bhattacharya learn it for the petitioner. And Mr. Gogoi learned it government advocate for respondent number 1 and 2. Then also heard Mr. A. Pupon learned standing counsel for the GAD. GAD. And also heard Mr. Barkuzari for the finance department. Person to order of this court dated 14/5/2025, Mr. Gogoi has produced one letter addressed to him by Additional District Commissioner Kokrajhar, wherein it is stated that budget and financial sanction for an amount of rupees 9,22,180 rupees has been received from the government. However, the fixation of ceiling has not been received for which payment would not be made to the concerned petition. Mr. Corpusary, learned counsel for the finance department submits that unless the proposal is received by the finance department, he could not obtain any instruction in this regard. And at this instance, Mr. Open learned counsel for the GAD. GAD submits that he may be granted 1 week time to obtain up-to-date instruction as regard whether the proposal was sent to the finance department or not. In that way of the matter, Resti is to list the matter after a week, and Mr. Okan shall obtain up-to-date instruction and apprise this court of next day. Letter produced before the court today shall be part of that.
What do you want?
Wait, please, your lordship. We have filed one IA praying for substitution of the deceased respondent number 1.
Praying for?
Substitution. The
Substitute.
deceased respondent number 1.
Yes, Mr. Hussain, any objection? No objection.
Madam, I'm referring from respondent 11, 12, the statement.
11, 12.
Former respondent. We also don't have objection. So it may go ahead, madam.
Heard, miss?
S. Ajmi.
Yes?
Ajmi.
And
Learned
one more thing,
counsel
it was
for the-
in the limitation period, there is no delay.
Learned counsel for the applicant, Mr. Hussain for respondent number?
And all the respondent.
All the respondents? No, except respondent number 11 and 12.
Yeah.
11
For 11 and 12, the state of Assam proof of.
and also heard Mr. Bhattacharya for respondent number 11 and 12. It's interlocutory application under order 22 Rule 4 of the Code of Civil Procedure is prepared by the applicant for substitution of the legal heirs of deceased respondent number 1 in RSA number 225 of 2018. The learned counsel for the applicant submits that deceased respondent number 1.
Shukuran. MD Shukuran. MD Shukuran.
MD Sukurali. MD Sukurali suffered demise on 28/3/2025, leaving behind 2 legal heirs. No, 4 legal heirs. Namely, Mariam Bibi, wife, Saida Bibi, daughter, Sajida Khatun, daughter, and Moksidul Ahmed. So, and they are required to be implemented as respondent in the RSA number 225 of 2018. Mr. Hussain submits that he has no objection. Mr. Hussain and Mr. Bhattacharya submits that they have no objection in implementing the legal heirs of the deceased respondent number 1, since the application is filed well within the period of limitation. Taking note of the submission of learned counsel for both the parties, this court is inclined to allow this application. The legal heirs of deceased respondent number 1 be implemented as a respondent in RSA number 225 of 2008. In terms of this IS and disposal, the learned counsel for the applicant shall file amended cause title in the RSA number 225 of 2018 within a period of 1 week from today.
Substitute 1.1, 1.2, 1.3.
It is there. No, in the application it is mentioned.
Moksidin Alom. Alom, not Alom. My lord, after the corrections are made, the final petition will have to be again served, I suppose. 22.
The counsel for the applicant also furnish a copy of the amended memo of appeal on the amended cause title of the appeal to the learned counsel for the response.
Please.
32.
With your lordship, I application your lordship for allowing the applicant to amend your lordship, the post title and their prayer your lordship. Your lordship may see para 2 it starts forward from para onwards your lordship. The applicant begs to state that after filing a listing of RSA number 203/24 before the honorable court and
Will issue notice that this is there?
no, your lordship, none appeared from the other side, your lordship. Notice has been already issued, your lordship.
Where?
Your lordship, in the main RSA, your lordship. The steps taken on 2nd of your lordship, 22nd.
No, in respect of this IA.
Yes, your lordship. None appear for the other side, your lordship. Till date, your lordship. In the main RSA also, your lordship. Simply, your lordship, the rectification is required, your lordship.
So do we consider it without hearing the other side?
No, your lordship, it's not necessary, your lordship. Just simply, your lordship, the case number, title suit number has been wrongly reflected, your lordship, inadvertently, in view of the office note dated 10/3/25, actually, your lordship. Your lordship, I kindly see para.
In respect of title suit number.
Yes, your lordship. The title suit number 343/2014, it should be. Actually, inadvertently, it has been recorded as your lordship in technical mistake occurred in the title, in the RSA, your lordship, in the prayer as well as cost title, your lordship.
Correct is 343/2014
Yes,
instead of 343/2021.
21, yes. That much.
Heard Mr. P. Sharma, learned counsel for the applicant. This application under Order 6, Rule 17, reduced Section 151 of the Code of Civil Procedure is prepared by the applicant for allowing him
Yes.
to amend the appeal. Allowing them to amend the appeal
In cost title and prayer, your prayer portion.
in
of
cost title and pair portion of the
memo of
aforementioned
appeal.
appeal. Mr. Sharma, learned counsel for the applicant submits that in the memo of appeal and also in the cost title of the memo of appeal and also in the pair person, the number of titles suit ought to have been mentioned as 343 struck 2014 instead of 343 of 2020.
21.
As such, there is a requirement for correction of the aforementioned title suit in the cost title and also in the pair person as title suit number 343 of 2014.
Instead of your lordship, instead of 343/2021. your lordship.
Okay. In view, taking note of the submission of learned counsel for the applicant and also considering the facts and circumstances of the record, this application is allowed the cost title and the pair person of the appeal. No, in the memo of appeal, the cost title and in the pair person, the number of title suit number 343 2021 shall be read as 343 2014
Yes.
for all purpose. In terms of this, I stands closed. Corrected cost title on corrected cost title and also the papers be furnished. No. Corrected memo of appeal be furnished submitted within 1 week from today.
Please.
33.
Yes.
Is your lordship. We have no objection in this.
No objection.
No objection.
My lord, I have furnished a copy of your lordship's order in a similar matter. Your lordship had passed orders. The similar order can be applicable in this matter also, my lord. Similar facts. WPC 938 of 2025, my lord. There are multiple petitioners. In my case, there is only one petitioner. Paragraph 14 and 15, my lord. Regulation 3A. Same facts, my lord.
No. Here we have to incorporate only regulation 3F.
Only 3F. In fact, what had happened, my lord, in this.
No. Whether anything more is required to be added.
In fact, my lord, in the IA, in paragraph number 6, I've made a categorical submission subject to if your lordship deems it fit or not within a reasonable time. That is all that we seek, my lord, because what will happen is that if there's no timeline given, the 3F benefits will be terminated by the government. Now the government has done nothing. In fact, pursuant to your lordship's order in 938, the individuals have already been inducted into 3F.
Individual?
The individuals, my lord, in WPC 938 of 2025, they have already been inducted into 3F. There is no dispute to that. In fact, the timeline help. That is only my submission. If your lordship deems it fit.
Timeline has to be incorporated.
Yes, that is my prayer, lordship. Subject to if your lordship deems it fit. I'll leave it to your lordship discretion. Otherwise, it's an open-ended time limit which the government might delay. And in fact, will become.
Who is appearing for the other state respondent?
My lord, the same counsels who appeared in that matter also, Mr. Tabildar had appeared in the matter, if I'm aware.
So can we do this without hearing Mr. Tabildar? Is fixing of timeline. That 3F, there is no problem in incorporating this regulation 3F.
Yes, in fact,
But
yes.
timeline fixing without.
If your lordship permits me, I'll call Mr. Tabildar or Mr. Simanto Das right now.
Yes, call them.
Yes,
Any one of them.
Yes, madam. I'll do that. I'll just
better to hear them.
Yes, absolutely, madam.
34.
But it is IS for condonation of delay of lordship 13 days. The notices make.
But Mr. Sharma learned counsel for the applicant. This interlocutory application is preferred under section 173 of the MB Act related with section 5 of the Limitation Act is preferred by the applicant for confirmation of delay filing appeal against the judgment that ever dated 25/4/2024 passed by the learned member MSCT Jurat Motor Accident Claim Tribunal Jurat in MSC case number 7 of 2007. Condonation of delay of 13 days.
13 days, 1-3.
First, the application, let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by the process within a week from today. Place the matter after 4 weeks.
35.
My lordship, the matter has come up for the first time. We have filed IR also. Delay of 23 days.
Delay?
23 days.
Third miss?
M. Chetia.
M.
Chetia.
Chetia, learn it for the applicant. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant. National Insurance Company Limited for confirmation of delay of 23 days in preparing connected appeal against the judgment and order dated 26/12/2024. Passed by the learned member, Motor Accident Claim Tribunal number 3, Government Path. Where is the application? Let notice be issued to the respondents, returnable in 4 weeks. They be taken by registered post with AD and also by legal process in the week from today. List the matter after 4 weeks.
36.
May I please, lordship, same order may pass, lordship. There is an IF for delay of 186 days. 186 days.
186 days.
Obliged.
37.
None appears for the applicant for one week, the matter after 1 week.
38.
Your Lordship, this is an application for condonation of delay of 100 days, Lordship.
100 days.
100 days, Lordship.
Yeah.
39.
Lordship, similar prayer, Lordship. Deed of 257 bit,
Same. Okay,
39.
okay.
Timing 33.
Okay.
Lordship, our name has not been reflected.
Education, sir.
Higher education.
So
Lordship,
have been served.
Lordship, that's why we have missed the matter, Lord.
My copy, I just had a conversation with Mr. Simanto Das. He's aware because a copy was served on him. Simanto Das right now is not in the premises of the court, my lord, this honorable court. That is, I'll leave it to your lordship if your lordship deems it fit. Otherwise, it's a very time-bound exercise that the government has taken for 3 years. That is my
Like,
plea.
Mr. Upamanya,
Yes, Lordship.
the matter is very simple.
So people,
While passing the order, this court has not incorporated regulation 3F only. That has to be incorporated. Then his further prayer is that the one timeline has to be fixed by this court, within which this order has to be implemented. That is only. Heard Mr. Sharma, learned counsel for the applicant.
Similar line.
And also heard Mr. D. Upamanya, learned standing counsel for the Higher Education Department, and Mr. Y.N. Monto, learned counsel for the respondent number 4. 3. Respondent number 3, and you? B does for respondent number 4. Respondent 4. This interlocutory application is prepared by the applicant for clarifying the judgment and order dated 28/4/2025 passed by this court. So Sharma, learned counsel for the applicant, submits that while passing the order dated
28/4/2025.
In paragraph number
14, my lord.
in paragraph number 14, inadvertently the word regulation 3F has not been incorporated, and as such the applicant herein are facing some difficulties, and further Mr. Sharma submits that in the said impugn order, no timeline has been fixed by this court for implementation for carrying out the exercise within which the same has to for completion of the exercise. And the same is also required to be fixed. Mr. Upamanya, learned standing counsel for the Higher Education Department, Mr. Mohanto for respondent number 3, and Mr. Das for respondent number 4, submits that they have no objection in the event of allowing this interlocutory application. Whereas taking note of the submission of learned counsel for both the parties, it is provided that henceforth in paragraph number 4, after the word Polytechnic of Assam shall be incorporated. No, the word regulation 3F shall be incorporated. And further, it is provided that the exercise mentioned in the said order, shall be carried out within a period of 10 days or 1 week from receipt of.
I'll leave it my
2 weeks. Lord.
No, in the meantime, that 3 months will
10 days, 10
10 days.
Yes, similar to this. Lordship.
My lord, it'll be paragraph 14.
14, yes.
Yeah.
Yes,
Of
the
the-
lordship had dictated it as paragraph number 4, inadvertent. 14.
Paragraph number?
14.
Yes, 14.
Yes. No.
In terms of this, I stands disposal.
For hearing, item 48. My lord, the amended order will be a part of the writ petition, my lord. That's since the IA has a separate order. I understand that your lordship will need to pass that order in the WPC also, allowing the IA, subject to correction from this honorable court.
Right. Okay. In view of the order passed in the IA,
Yes, madam.
necessary correction may be made in the order dated so in the WPC number.
WPC number 1188. I'm grateful, my lord. I'm grateful. For hearing 48.
Lordship, during this matter, I have filed my affidavit today, Lordship, at around 2:30 PM. So that has not been on record. So let it come after 2 weeks, Lordship, because this bench will not be here, Lordship. Can it be, Lordship, on? 17th of June, Lordship. I filed my affidavit.
17th.
Lordship.
Heard Mr. SK Das, learned.
Also, this bench will not be there.
Yes.
Then also heard Mr. D. Upamanya, learned, standing constable, higher education department. Sir Upamanya submits that he will be filing the affidavit in opposition.
Lordship already filed, Lordship. Around 2:30 this.
Today.
Yes.
He has already filed his affidavit in opposition today. And he pays for listening the matter of 17th.
17th. 19th.
19th. Here is accordingly allowed, recessal is the matter of 19th.
I leave.